I'd like to call this meeting of the Northwest Local School District Board of Education to order. Mr. Bertram, would you please call the roll?
Mr. Detzel?
Here.
Mrs. Detzel?
Here.
Mr. Heather? Here. Mr. Harlow?
Here.
Mr. Unger?
Here. I'd ask that you all join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Our next item is approval of minutes.
Yes, and in the system you have the June 2nd regular meeting minutes for approval. The treasurer and superintendent recommend the Board of Education approve the minutes as listed.
So moved.
Second.
Motion's been moved and seconded. Is there any discussion? Hearing none, Mr. Bertram, please call for a vote. Has everybody voted? There's the results. Motion carries 5-0. Next item, financial reports of the treasurer.
Yeah, under the consent items, we have several reports, standard reports from the treasurer. Randy, do you have any comments on these?
Just May reports, and we'll be coming to you shortly with June and the final for fiscal year 14.
The treasurer and superintendent recommend the Board of Education approve the financial reports as listed.
So moved.
Second.
The motion's been moved and seconded. Is there any discussion? Hearing none. Mr. Bertram? The motion carries 5-0. Our next item is certificated licensed personnel retirements and resignations.
Yes, we have 5 certificated resignations, 5 extra duty resignations, and 4 procedural extra duty resignations. The superintendent recommends the Board of Education approve the certificated licensed personnel retirements and resignations as listed.
So moved.
Second.
The motion's been moved and seconded. Is there any discussion? Hearing none, Mr. Bertram, please call for a vote. The motion carries 5-0. Our next item is classified personnel.
Under classified, we have 7 classified resignations and 2 procedural resignations. The superintendent recommends the Board of Education approve the classified retirements and resignations as listed.
So moved. Second.
The motion's been moved and seconded. Is there any discussion? Hearing none, Mr. Bertram. The motion carries 5-0. Our next item is the Student Activity Handbook for 2014-2015.
Yes, we have several handbooks that were presented at the last meeting, so they'll be coming up throughout. This is the first one. So the treasurer and superintendent recommend the Board of Education approve the 2014-15 Student Activity Handbook as listed.
So moved. Second.
The motion's been moved and seconded. Is there any discussion? Hearing none, Mr. Bertram. The motion carries 5-0. Next item, self-funded workers' compensation for fiscal year 2015, Fund 027.
Yeah, I'll turn this over to our treasurer, Randy Bertram. We have several items coming up that we need to do as the end of our current fiscal year or the beginning of our next fiscal year. The current one ends on June 30th. The new one begins on July 1st. So I'll go ahead and turn it over to Randy for an explanation.
Yeah, the self-funded workers' compensation program is the program we took over 2 years ago to self-fund workers' comp. Currently, we're spending right around $250,000 to $260,000 a year on our self-funded program, and we're well above $600,000 when we were doing it through the state. So this is a program I recommend we continue with the savings.
The treasurer and superintendent recommend the Board of Education approve the continuation of self-funded workers' compensation as listed.
So moved.
Second.
The motion's been moved and seconded. Is there any discussion?
Just want to thank you again, Randy, for suggesting this and getting this pushed forward, because as you can see, it has saved us quite a bit of money.
Thank you.
And I was kind of curious, how is our claims experience compared to other years? I don't know if that's something you have.
I don't have it available
Okay,
right now,
that's
but I
fine.
could tell you we've had quite a few claims, but nothing major. They've all been minor claims for the most
But dollar-wise, it's kind of floating about the same.
part. No, claim-wise, I think we're down
Okay.
a little bit,
Well,
total
great.
dollars. Yeah.
So there's been a motion and a second. Any further discussion? Hearing none. Mr. Bertram? Motion carries 5-0. Our next item is a resolution to accept the Local Government Services section of the Auditor of State Engagement Letter of Terms and Services for financial statements and the CAFR for fiscal year 2015.
This is the contract that we have with the auditor of the state to provide services to us to complete our CAFR on an annual basis. And this is something that we started when Brian moved full-time out of the full-time accounting position to a split EMIS accountant position. So we need their services at an annual rate of no more than $15,000 to help us complete that.
The treasurer and superintendent recommend the Board of Education approve the Auditor of State's engagement letter as listed.
So moved. Second.
The motion's been moved and seconded. Is there any discussion? I would just like to note for anyone interested that 4 or 5 page letter is available right on the ESB site if you care to read it. Is there any other discussion? Hearing none. Mr. Bertram?
Okay, I somehow got logged out, so just be a second. Yeah, I'm good. I think so.
And the motion carries 5-0. I'm always very careful about not doing that. Yeah. Our next item is Certificate of Estimated Resources and Appropriations for fiscal year 2014 final.
This is the annual requirement that we submit this to the Hamilton County Auditor. And what this is, it's my final estimate for fiscal year 14 on available resources and expenditures.
Is there any recommendation to?
Oh, what's that? I don't know what's happened.
They're looking at mine.
He just got signed out.
It's just, it's just taking me, just keeps taking me out.
The treasurer and superintendent recommend the Board of Education approve the Certificate of Estimated Resources and Appropriations items as listed.
So moved.
Second.
The motion's been moved and seconded. Is there any discussion? Hearing none. Mr. Bertram? The motion carries 5-0. Our next item is temporary appropriation for fiscal year 2015.
Yes, this gives me permission to start spending money July 1st using FY15 appropriations. This is an estimate. Treasurer will come back to the board for a certification as you just passed for fiscal year 14. It'll be the first one for fiscal year 15, no later than October of this year.
The treasurer and superintendent recommend the Board of Education approve the FY15 temporary appropriations as listed.
So moved. Second.
The motion's been moved and seconded. Is there any discussion? Hearing none. Mr. Bertram? The motion carries 5-0. Our next item is petty cash and change funds for fiscal year 2015.
Again, this gives us permission to operate the petty cash and change funds for the upcoming fiscal year, and there are no changes from last year's amounts.
The treasurer and superintendent recommend the Board of Education approve the petty cash and change funds for fiscal year 2015 as listed.
So moved.
Second.
The motion's been moved and seconded. Is there any discussion? Hearing none. Mr. Bertram? The motion carries 5-0. Our next item is new funds.
This gives us permission to operate the new funds for fiscal year 15.
Superintendent and treasurer recommend the Board of Education approve the new funds as listed.
So moved.
Second.
Motion's been moved and seconded. Is there any discussion? Hearing none, Mr. Bertram? The motion carries 5-0. Our next item is advances and transfers.
Yes, the advances and transfers, give me a second to open the file. This year, since I did this earlier than I have in past years, we had some project cash requests that we put into the state of Ohio. And at that time, we're assuming that I would not receive those monies back from the state by June 30th. However, I have received those monies. So I would expect advances to come in no higher than $400,000 this year, and we will come back to you in July with the actual amounts and pay those back in July as well.
So the treasurer and superintendent recommend the Board of Education approve the advances and transfers as listed.
So moved.
Motion's been moved
Second.
and seconded. Is there any discussion?
Randy, just curious, the 30,000 St. Ives, what is that?
Well, actually, we bill St. Ives for additional services this year, and they owed us $41,000 for those services, and I made the assumption we wouldn't get the check in case we didn't, but they've actually paid us, so there
Awesome.
won't be an advance there.
Okay. Thank you.
Is there any other discussion? Hearing none, Mr. Bertram? The motion carries 5-0. Next item is bus purchases.
Yes, we opened some bus bids back on June 9th. We received bids from Rush, who is an international dealer, and Cardinal, who deals in Bluebird. The Rush was approximately $2,000 more per bus. However, they met our specifications for our engine while the other one did not. So they were the only responsive bid in terms of our specifications. So the recommendation then from Mr. Bowling is to purchase, let's see, 10 buses, I'm sorry.
972 passengers and 154 passengers.
So a total of 10 buses for $835,000, $835,500 with the $21,700 trade-in deduct. So superintendent recommends the Board of Education approve the purchase of buses as listed.
So moved. Second.
The motion's been moved and seconded. Is there any discussion? So we did get at least 2 people that responded, but one of them didn't respond because they
Correct.
didn't have the right engine size, or
They went with a different parent bore engine versus we wanted.
I
the West
remember
State
that being an
because it's
issue in other
rebuildable.
years.
Yep.
So most of our equipment has exact same
Correct.
engines, and that's why we're...
Interchangeable parts.
Okay. Is there any other discussion? Go ahead and call for a vote. And the motion carries 5-0. The next item is resolution to declare students impractical to transport.
Yeah, we've done several students this year. We have just a small list remaining here that we need to declare to impractical to transport. So superintendent recommends the Board of Education approve the resolution to declare students to impractical to transport as listed.
So moved.
Second.
The motion's been moved and seconded. Is there any discussion?
Just a question, Randy. What does a family get if, their child is impractical to transport? What kind of reimbursement
I believe the amount's about $278.
per student?
Yeah.
Yes.
Okay. All right, thank you.
And also, Randy, there was a longer list that we approved a couple meetings ago. Is this a supplemental list, or were other arrangements worked out, or how did that?
Yeah, this was just an additional list. We have a deadline of when they turn it in, and there was a list of 5 that were like 2 days too late. So we went ahead and just added it to the board to approve.
Okay.
Is there any other discussion? Hearing none, Mr. Bertram? The motion carries 5-0. Liability and property insurance coverage.
Yes, we use a brokerage service that goes out and gets bids and quotes from several different insurance companies. So, Todd, do you have anything to add to?
Yeah, he's a broker for the SIC group. He gets rates from assorted companies. He negotiates the best rates for our district and others independently. As some of you probably know, there's been some restructuring of insurance companies. 2011-12, he had us a 5% decrease. 2012-13, we had a freeze. Last year, where it was a small increase. This year, it's an 8% increase overall, considering the winter we had and some of the accidents. It was a pretty good rate, we felt. Tom takes care of us and does a great job as a broker.
So the superintendent recommends the Board of Education approve Trident as our liability insurance carrier and Liberty Mutual as our property insurance carrier.
So moved.
Second. The motion's been moved and seconded. Is there any discussion? Hearing none. Mr. Bertram? Motion carries 5-0. Our next item is certificated licensed personnel.
Yes, we have one administrative appointment, and he was not able to be here with us, but we'll bring Adam at a later meeting to be introduced to the board. We'll be at Colerain Elementary as assistant principal. We have 9 initial appointments. We have 1 administrative contract, which is a part-time contract for one of our expulsion hearing officers we use. Several summer intervention teachers. We have 1 home instructor and several extra duty contracts. The superintendent recommends the Board of Education approve the certificated licensed personnel items as listed.
So moved.
Second.
The motion's been moved and seconded. Is there any discussion? Hearing none. Mr. Bertram? The motion carries 5-0. Next item is event worker job description.
We had a presentation at a earlier board meeting where, due to IRS regulations, the folks that work at our events that are not our employees, they need to be our employees and run through payroll. Most of them are already our employees, but we have a few that work just as some extra income outside. So we have to have a job description approved as well. So this is basically the job description for the event workers. If they're not current employees, they'll be brought to the board to be hired, and then they'll be processed through our payroll system. So the superintendent recommends the Board of Education approve the event worker job description as listed.
So moved.
Second.
The motion's been moved and seconded. Is there any discussion? Hearing none. Mr. Bertram? The motion carries 5-0. Our next item is a classified personnel item.
Yes, we have 2 initial appointments, one of which is Elizabeth Witt, who will be our new accountant benefits assistant supervisor. We have 5 classified subs, 5 changes in status, and 1 extended service contract. The superintendent recommends the Board of Education approve the classified personnel items as listed.
So moved.
Second.
The motion's been moved and seconded. Is there any discussion? And is that a replacement position for your office?
Yes, that's
That's the one we talked about a couple months ago?
Yes.
For the restructuring.
Backfill the payroll supervisor. That's the vacancy.
Great. Is there any other discussion? Hearing none. Mr. Bertram? The motion carries 5-0. Our next item is 2014-2015 curriculum handbooks.
We have some additional handbooks that were presented at the June 2nd meeting here today for approval. So curriculum is asking for approval for the credit flexibility, PSEO, which is post-secondary educational options, and field trip handbooks. The superintendent recommends the Board of Education approve the curriculum handbooks as listed.
So moved. Second.
The motion's been moved and seconded. Is there any discussion? Hearing none. Mr. Bertram? And the motion carries 5-0. Our next item is student services, attendance, and enrollment books.
Again, we have additional handbooks that were presented at the June 2nd. This time we have the attendance handbook and the enrollment handbook to be approved. The superintendent recommends the Board of Education approve the handbook items as listed.
So moved.
Second.
The motion's been moved and seconded. Is there any discussion? Hearing none. Mr. Bertram? The motion carries 5-0. Our next item is student handbooks for 2014-2015.
Yes, and these were presented at the June 2nd meeting as well. These are the student handbooks for each school in the district. The superintendent recommends the Board of Education approve the 2014-15 student handbook items as listed.
So moved.
Second.
The motion's been moved and seconded. Is there any discussion? Hearing none. Mr. Bertram?
The motion carries 5-0. And the next item is law firm interviews. We have,
Yes, our first law firm here this evening for the next hour is Taft, and then we will have Ennis Robertson Fisher, and then we have Bricker and Eckler. And I think we have a representative from Taft out in the audience currently, so go ahead and call him up and get started.
okay. And at our law firm interviews last week, this is an open meeting and everyone's welcome to stay, but we did ask that any firms that have not presented yet, if there's anybody here from the other two firms, you're welcome to stay, but if you care to, there's a conference room over there just so you're not hearing the questions ahead of time. So I guess Taft is...
here from those
Okay,
two firms.
I didn't recognize everybody, so...
I apologize to Adam Miller, who's our primary head of our education law group. He's in the JAG Corps, and we called him to duty, and so he is unavailable tonight. He's in the JAG Corps as well, and was called on special duty for an assignment, and so he is unavailable tonight.
Well, thank you for his service to our country. There is a microphone, and what our method is here is we give you 1 hour. You're free to use that hour as you wish, although we have 16 questions, and we'd like it if you'd leave us time to ask and get answers from each of those questions.
Well, I'll give you, you want me to stand
I
over
think,
here?
is there a red light on right there?
That sure is.
Okay, you should
Yeah,
be,
that's
be
good.
fine then.
Hopefully Ryan will walk in here momentarily. I'll just introduce myself. I'm Brian Dershaw. I'm within the packet that you've received on our law firm, Taft, Phineas and Hollister. We are appreciative of the opportunity to interview for this position. We're glad to see it open up for a bidding process and to bring in what we can do for you and show you what we've done for others. Taft has been around Cincinnati forever. I was with a client about an hour ago who's been in Cincinnati since 1894. We've been there since 1885. We're trying to find out who was here longer. My primary practice is labor and employment, and I work with school districts, colleges, universities, as well as private and public sector employees. Adam Miller, who's not here, who would be your primary presenter, had he not got called for duty, and not told me about this yesterday, that I would be our primary presenter. His practice is education law. I am located here in Cincinnati, in the Cincinnati office. Adam, I think, is based out of every office because when he's running the Education School Board circuit, he is all over the state of Ohio. So his primary residence is Columbus, but he has offices in Cincinnati and in Dayton as well. Ryan Smith, who I'm hopeful will come in here shortly, is one of our associates from the Dayton office. Ryan came to us from the Ohio State University. While he was at Ohio State, one of his clerkships was with CERB and working directly with Gene Brundage, so he's very familiar with the CERB process and has been helping us on the ULP claims with CERB. Outside of that, I am a father. I have 2 children, both in public schools. Well, the one's only 4. One is going to be a 3rd grader, and the other will be entering into her final year of preschool. I am a product of the public schools system myself. The Hilliard City Schools in Columbus is where I grew up. It seems to have a fairly similar demographic, at least when I lived there, when it was only 1 high school. Now I think they have 3 or 4, to the Northwest local schools. I live just across town on the east side of Cincinnati, but I'm familiar with all of Cincinnati and have been here since 1997. Been practicing law since the year 2000. So I'll open it up to questions, and maybe we can have more of a discourse. Go through our proposal as well.
And if it's all right for the board, I will ask the question, and would it be okay if he passed on it with the hopes that his other person showed up? So I'll just ask these in the same order I asked the first 2 firms, and if it's something you want to pass on and come back to, I guess that'd be okay with the rest of the board. Okay. The first question is, explain the differences between the current law for OTES, OPES, and recent changes in that legislation.
Well, I would have to defer that to Adam.
Okay.
And he is not here, so maybe this will be
That's
difficult
fine.
for this
No,
whole
that's
interview.
fine.
And if you have anything that you want to email me, I could probably get him to respond tonight. But unfortunately, that doesn't allow other people to hear it. If Ryan walks in, we can...
Okay, we'll come back to that. That's all right. Second question, have you reviewed our Northwest Local School District labor contracts? What are your comments about the contract provisions?
I personally have not reviewed the Northwest local labor contracts. However, I've reviewed many labor contracts and can talk in general. One of the things that we like to do at Taft is we have a significant labor background. One of the true labor law firms on the management side still within the country. 40 years ago or so, we would have been one of the few within the country people who were on the go-to firm list. Others have developed that practice. One of our partners and the founder of my group, the Labor and Employment Group, he wrote the Taft-Hartley Act under Senator Taft. So we have a strong background with labor. What we'd like to do is work with the public sector, the boards with whom we have been retained, to find out what it is that you expect from your labor contract, what it is that the employees classified and certificated expect from their labor contract, and how can we craft something that allows the parties to move forward in a more collegial and cohesive manner, as opposed to running in and out of arbitrations, grievances, unfair labor practice charges. We have worked over the past years in simplifying collective bargaining agreements, ensuring all terms are clear and understandable, and that anybody reviewing it understands how it can be enforced or how it can be applied. That's what I would look at if I were looking at the Northwest Local School District, is to find out how do we get this in a manner that the employees, management, the board, and the attorneys on the outside all know what's happening here.
And then what we did last time was we allowed anyone up here at the table to ask follow-up questions, but so that you're in control of the time, I'd like you to ask, is there any follow-up questions?
Sure. And any follow-up questions to that?
That way you're in control of the time and
Yeah.
we're not taking your time.
You have as much of my time as you want.
Okay.
Don't worry about that.
Was there any follow-up questions?
I was just curious, how many other public school contracts have you negotiated for?
On the public school, let's see here, we've got a list.
And we have a association for our bus drivers, it's OPSI, and then also for our teachers, so we have two
Okay.
different.
I know for certain we negotiate, well, we don't negotiate Cincinnati Public Schools as much because one of our former attorneys is now in-house at Cincinnati Public, although we do their labor work when they need it outside. Sycamore Community Schools, Dayton, Cleveland. I know that the list down here that Adam does are Stowe Monroe, Greene, Northwest Passaic County, Northwest Local District. I personally, until Adam joined, most of mine were colleges and universities. And so I used to be the outside labor counsel for Cincinnati State, did labor work for Shawnee State as well as Central State. Also, I serve as labor counsel for utility companies, so Dayton Power and Light being one of those. Variety of, through our department and through the individuals you see in here, I think we've negotiated thousands of collective bargaining agreements in the private and public sector and have our tentacles into many locally and nationally.
And then Adam Miller would be the person that we would use with Taft to negotiate those here.
I think that Adam and I, if we were retained, I think we would sit down with the board and discuss who would be the appropriate team to negotiate.
Okay.
And it would probably be Adam or me, and then Ryan Smith, who might be just standing out in the hallway, would be an associate who we would include on that who's participated in these.
Okay. You're free to open up the door.
Let me check. I checked a second ago.
Okay.
If I can tell it by a profile, he just pulled in.
That's fine. You're doing very well handling this part.
You're yeah. Well, it was interesting. I won't digress too much, but when I received the call from Adam yesterday, I was going to come and support as Adam presented this, and he told me that he was going to be at the JAG Corps, and could I get here, thinking this was last night. And at that point, I was presenting to 200 funeral directors in Kentucky, in Louisville, Kentucky. And I said, well, it's going to be a livelier crowd than this, but I didn't even know what I was walking into.
Funeral directors can be a pretty funny bunch.
Oh, they're a great bunch.
Dealt with plenty
They're
of
a
them.
great bunch. On our list, I am general counsel for the Cincinnati College of Mortuary Science. And so,
Which is another school.
Here's Ryan.
Hi,
You can introduce yourself.
I'm Ryan Smith. I'm an attorney out of the Dayton office. I primarily focus on labor and employment law. I've got a lot of experience in the public sector in particular. I worked with the State Employment Relations Board as their counsel for a few years. So I've got a lot of experience handling unfair labor practices and also represent several school districts, mostly handling labor and negotiations.
Okay. Well, hi, Ryan, welcome.
Thank you.
For right here.
The way we had this set up was a short presentation on just who Taft is, and then we've got 14 questions.
Okay.
And we had bypassed the first question, and,
If you want to re-ask it, he may know.
okay, I will go ahead and ask the first question over then. Explain the differences between the current law for OTES, OPES, and recent changes to that legislation.
I think that's something that we'd have to defer
Okay.
as a school law question.
That's fine. So then I'll go to the third question. Do you feel like you answered the second question?
Yeah, unless anyone has any follow-up questions beyond.
Okay, then we'll go to the third question. What is your approach to labor negotiations? How will you help to advocate on behalf of our board?
Start with that. Well, there's a variety of negotiation types, and most people think of more traditional or the interest-based. Ours is sort of a modified interest-based labor negotiation. That's what I discussed earlier, is getting to understand the interests of the parties. Because in doing that, in my experience working with public universities, is we've discovered our interests on management side are often totally different than the interests on the employee side, and there's a way to bring those together. Because what they may find is important, we can get something else that we want that's much more important to us. For the school board, I think that's where we would start. We certainly still get involved in the very traditional, pound your fist, hours at the collective bargaining table, demanding a position. But in order to save money for the school board and the school district in the long run, and to save time, the idea here is to find out what are the goals. So, we would spend time with the board and those on the negotiation team trying to understand what are the goals that you want to achieve. And then from that, we would work with the opposition to find out exactly what the goals are that they would want to achieve. And in turn, hopefully we can come to what I discussed earlier, is a clear and coherent and understandable agreement. There's always going to be a dispute. There's always going to be an unfair labor practice. I just did a hearing the other week where a guy got caught sleeping on the job and challenged the discipline that he received. Now, if I had told my mom that I was sleeping on the job, and then I'm going to go back and claim that they should have paid me for the 8 hours that I was sleeping, I probably would have gotten smacked. But that's how the world works, and ultimately, because this company had an issue of people sleeping on the job over the years, we found out that the way they had disciplined, now they're becoming more aggressive with their discipline. And those are sort of issues that we need to work with the board, with the bargaining team to find out is, what are the important issues? One of those important issues is something that's, related to discipline that you haven't effectively implemented over the years. That's something we need to effectively implement now. Because you don't want somebody who's sleeping on the job to challenge that as a disciplinary matter at some point in the future, if it's important to you. Ryan has done some recent negotiations, I believe, and so you can talk a little bit with the school districts.
Yeah, that's exactly something that we focused on. That was one situation where, unusual as of late, that the school district had some money to give, but it was also really important to them that they were able to implement a lot more flexibility, specifically in terms of how they dealt with hiring and promotions and movement of employees. They've been really restricted on that before, and so that's something that they were able to press as an issue in order to implement. And it was something that was well worth the economic compromises.
Any follow-up questions?
No, thank you. Okay. Our next question is, discuss your experience negotiating collective bargaining agreements with a teachers association represented by the Ohio Education Association or a bus driver association represented by the Ohio Association of Public School Employees.
We had a recent negotiation with the bus drivers. It was a contract. I think it was the most recent one that we had was a successor negotiation. It was relatively limited. The school district had absolutely no money to give. We were able to get, again, they were focusing on some of those non-economic flexibility issues, and we were able to implement those effectively without making any compromises financially. That was something that the union was understanding enough on that we were able to sort of push off some of those economic obligations to the back in terms of later years.
On our other negotiations with the Higher Education Association teachers and whatnot, often we are going into it anymore with not much money to give. And it makes it a difficult time. And then the same is true in the public sector in general and working with the AAUP, SEIU, IUOE on the university campuses, is that the universities have no money to give. And negotiations don't start so well when everybody starts from the aspect of the reality where the board and the district are of is there's just simply not money, to the lack of reality where people are saying, well, that school district got a raise, and that school district got a raise, and that university got a raise. Education, walking in, again, this is where sort of the modified interest-based comes in, is getting to the table with people recognizing that if it is a totally economic scenario where there's just not much money to give, then the negotiations we have been very successful in turning into what are those areas unrelated to the economics where we can give. The people are still happy to be employed by the school district, happy to have a job, and understanding that they got something, or at least got to continue something that in other places they don't get. And that's becoming more and more difficult, especially as I talked yesterday speaking on the Affordable Care Act and health insurance and issues associated with that. When I started negotiating public sector collective bargaining agreements, the universities I did it for had some of the richest benefit packages there were. These people did not realize that getting 100% of their health insurance covered was abnormal. That everywhere else that I was negotiating, nobody got that. And it's a struggle because those are the things you have to start scaling back on. Or you have to find other places to save money. So it is really becoming getting people educated and understanding what the process is going forward and what truly can happen. Because if you start in a position of somebody's not even in the ballpark, it takes a long time, you spend too much time and money on your attorneys, and we're not here to do that for you. We're here to find ways for you to profit from elsewhere other than working with the law firms. Any further follow-up questions?
Okay. We'll move on to student services special education questions. Number 5, explain the difference between school law and civil law as it pertains to student disciplinary hearings.
You want to cover that? I can do my best on that one, but you might. Well, student disciplinary hearings and disciplinary hearings in general, when you come into these issues, are not governed by the civil rules of procedure. They're not governed by the rules of evidence. They don't have that formal aspect of it. It's often more of an informal understanding argument of which side is appropriate. And looking at issues like just cause or with cause, was the discipline appropriate? Had it been fashioned in a manner in which it had been applied previously? Is it consistently applied that way? And is there any mitigating circumstances in those situations? In civil law, where I spend a lot of my time, we're very much bound by the strict rules of evidence and procedure, and the argument has to be defined by that. And so we're not looking at equity as much as we are looking at following and ensuring we're following the right process and that the evidence has been approached adequately.
Yeah, I would just add to that there are a lot of similarities in the sense that the real focus you can probably do well to translate the principles that you apply in student discipline to the civil side, which is really focusing on what the issues are, having a fair process, making sure that each side has had an opportunity to fully explain themselves. That's what's really important.
On the special education side, the differences between that and civil law, I think, greatly vary. On the aspect of the special education side is everybody from the school, superintendent, school board down, you're focusing on what's best for the student. And that's where the families, and coming from a family, I've got a nephew who is 18 years old, Down syndrome, he's got one more year of high school. I've gotten to follow the process of what it's like to work with the special education and the IEP and the different programs that the school districts have for him, and being an advocate. And that's where you take it away from the civil law side and almost get into the guardian ad litem side and the juvenile court of, this is somebody who needs to be advocated for, who's there, who hasn't been spoken for before. And the school district is part of that, and they're advocating for that person within the bounds of what they can do. And that's completely different from the civil rules. Where if you bring something like that in civil court, you're just looking at, well, here's what the law says, here's what we do, here's how we apply it. And there you're placed specifically with this is a child, that we all have a duty to ensure the appropriate educational requirements are met. Any follow-up questions?
No, thank you.
Anyone else? Okay. Question 6. Explain the relationship between IDEA services and 504. Define each term and the characteristics required for qualification under each category. If special education disputes do arise, how will you help to amicably resolve the disputes and help to avoid unnecessary additional cost?
I apologize, but we have to defer that one to Mr. Miller. Or Adrian Cunningham in Cleveland if you want to get a hold of somebody sooner. That's right up their area.
Okay, thank you. Number 7, please describe your experience dealing with complaints from the Department of Education Office of Civil Rights.
Let's start with that one.
Go ahead.
Well, from the Department of Education, complaints dealing with civil rights. I've also had a variety of complaints dealing with the Office of Nutrition. And then my experience goes in with the Office of Civil Rights, Equal Employment, EEOC, and OCRC. So I'm going to be a little broader. In dealing with complaints regarding civil rights, we have defined a fairly uniform process at our firm as to how to respond. The idea is, to adequately assess the situation, what the claim is, put together the appropriate packet, not necessarily everything they request. Oftentimes they request, between 19 and 38 items for your response. But once you put together the appropriate response, it's setting the stage and the picture as to why we were in the right or why that decision was appropriate. Typically, I don't have one, but this is probably closest, what I'll often do is you'll see a jacket tabbed, and so that when it gets back to the Office of Civil Rights, they can go through and go to each thing. So the story is told in a clear and concise manner, and from that they can provide their decision. Do you have any?
I was going to say, yeah, when we respond to those, just to add to that, our focus, is initially doing the investigation, and then, having a good understanding of what the story is, because 9 times out of 10, there's a legitimate story. The story is not the same that the complainant's telling, and our job is just to frame that story in a way that's clear and completely understandable. And that imparts of whatever educational or disciplinary objective were behind the decision.
Any follow-up questions?
No, thank you.
Question 8, how will you help ensure that the school district remains justifiably acknowledged by the Ohio Department of Education and others as properly serving children with disabilities?
Give it a run.
That's something I have to defer.
As far as any technical aspect of it, that would be something we would defer to Adam, who is our special
Okay.
education, and it falls within the proposal as part of the work that would be done on the retainer amount. But from that personal standpoint, what I said earlier, that's a significant issue. That's an issue where you need to be recognized as doing the right thing and doing the appropriate thing within the bounds that you can do it. And our simple way is, we may sometimes tell you, and this is what we have to tell a lot of our clients is, practically or legally speaking, here's what you can do. Practically speaking, here's what you should do. And that's one way to address an issue like that is, it may be that you're completely right on the law or completely right on the application, but the impact it could have on you as a school district, leaked into the press or anywhere else, may not be the time to follow that law so directly.
We don't have any follow-up questions.
There is some water here if you want.
Oh,
Thanks.
Our next question, number 9. Within the past year, our district has had high-profile incidents involving employee sexual contact with students. These incidents are destructive to our students, our district, our community at large, and damaging to the morale of our other employees. What proactive steps can we take to improve policy and abuse education among our employees and volunteers to assure that these incidents are minimized?
Being from around the area, I certainly know that this has been happening in this district, and it's been all over, and you guys have had to deal with a lot. One of the things that's within our proposal, but it goes beyond this. In this day and age, it shouldn't happen. Unfortunately, it does happen. We provide a very proactive training process. That is part of the proposal and part of the retention that we propose, where you tell us what you want and who you want us to train. Some of this you would think is just common sense. You shouldn't do that. Dealing with employers from 5 to 550,000 employees, I've learned over the years that some people just don't get it. And so what has to happen is appropriate training. It's effective. People are actually listening and understanding it. Appropriate discipline, that's effective. You know, on the early signs and stuff, you're not waiting for that last shoe to drop. You know, making sure relationships, you know, aren't, if they seem improper, investigate. But that's, you know, enforcement. Educate, enforce, and be consistent with that. Because you're going to run into issues where there's the person not listening, there's the person who doesn't show up to training, there's the people who just are there, you know, in the back whispering amongst each other who aren't paying attention because it doesn't happen to them or they don't care. Well, the other way to train people is when they see somebody else get called out that what they're doing is inappropriate. People notice more when their colleagues get in trouble than they do when the lawyers are standing up. Now, one of the reasons why we do the training is it is impactful when the law firm walks in and does it. One, they think you've spent a lot of money on us to come and do that, but the other is, you know, it's serious. And a lot of times, you know, anytime I get a sexual harassment case to defend, you know, when we're done, no matter if we're successful or if we've had to settle or if it's had to go all the way through trial, we typically will have a sexual harassment training when we're done. And there have even been clients who will have it where instead of us giving it, they'll hire a third party to come give it, but they'll have all the lawyers show up and sit in it as well, just so that the management team understands, or the team that's been brought in understands that these issues shouldn't happen. We really thought with sexual harassment over the years that it would go away. You know, that people would finally catch on and say this is not something we can continue, that these are not claims that we should be defending. Unfortunately, it seems to be an uptick, and it only seems to be getting more and more difficult to deal with, especially with school districts and relationships with students.
I was going to say, and I think, you know, probably a reason for that, I mean, maybe there's more sexual harassment occurring, hope not. You know, there's probably more complaints, you know, people are more aware, you know, of outlets for that and what conduct really is inappropriate. And so that makes it all the more important, you know, that appropriate investigatory steps are taken each time a complaint is made, you know, that a full investigation happens, you know, when that resolution occurs, so you can really nip people's complaint.
If I could add on to you know, one of the things that I work on very closely is cyber harassment, cyber bullying, and typically within the workplace, although there's cyberbullying that relates to within children as well. You know, that falls into the criminal courts. We don't have to encounter it as much. But with cyber harassment, that seems to be where the uptick is coming because of the proliferation of information and the ability to contact other people and to engage in communications that may seem innocent to start, that end up going down the road somewhere they shouldn't go. And so what we've had to do is work with our clients on appropriate ways that your network is secure, appropriate ways that people are using it, and how they're using social networking while at your workplace. If you use, you know, everybody's got one. These create some of the most liability for any company there is in the world for the amount of information that's on it. But people are using these more and more. So when you can communicate with others, it seems to open a door, potentially from teacher to student, that previously you didn't have. And so there's ways of training and getting people acknowledging having appropriate policies as it relates to the use of smartphones. All of those are ways in which we try to mitigate the risk of it happening and the ability to acknowledge when it's happened and we know it's happened quickly, and that we can respond to it quickly and it doesn't become, you know, tonight's news story.
Brian, on the proposal, you talk about administrative staff in service training. That would be part of the retainer.
Yes.
Are you also saying that you would be able to be in front of teachers as well?
I will gladly do training for anybody. I enjoy doing it. I would include it in there, as well. If you had something that was important to the school district and the board, that would certainly be as part of the proposal.
All right, thank you.
I typically do for all clients a few lunch and learns a year. We make proposals like this consistently across the board to clients, but even those that I've served for the past 14 years, we go in and sit down and find out what are some of the issues you're not calling me about, and we'll do it on a training session because people get concerned that every time they call, there's an hourly fee.
Was there any other follow-up questions? Okay. Our next question has to do with Board of Revision, financial, and open records questions. Does your firm currently have clients you are representing in matters against the Northwest Local School District? Have you had any in the past 3 years?
I cannot answer that definitively, but I can tell you it's potential, where we have had property owners and have had to do Board of Revision hearings where the Northwest Local School District has been a necessary party. It's not too often, and I don't know if it certainly happened within the last 3 years. For the school districts we do represent, we typically get a waiver, unless it's a waiver where the school district is saying, oh no, we want that property to be taxed, and at that level, and then they will deny that waiver. But we are a large firm with a lot of clients and have had a lot of Board of Revision. We don't have any open records actions of which I would be aware. We try to be on the side of the school board where it comes, that where we may not be is from the tax appeals and Board of Revisions, that we could have a client. You have some very large businesses in this area. It's highly likely some of them are clients.
Okay.
Any follow-up?
Question 11. Do you have a full-time tax attorney or attorneys dedicated to the practice of municipal finance and specifically knowledgeable of sections 141 through 150 of the Internal Revenue Code, the accompanying Treasury regulations, relevant IRS revenue rulings, and private letter rulings relating to municipal finance?
Yes. I don't know if he is if he's one of the folks in the packet. Brad Arnett, out of the Cincinnati office, is very familiar and involved with municipal finance and bond financing. I think that Ron Christian is in here. Ron also has significant experience in the tax department. He's in the private client group on municipal finance. Don Motley, I think, is also in here. Who's out of our Columbus office. Brad and Ron are both Cincinnati. Don is out of our Columbus office, and he's got significant tax experience with both federal, state, and local, and municipal finance. And in fact, part of his time is he is one of our ancillary companies or related companies, which is Focused Capital Solutions, which works with clients dealing with legislative and legal issues and related to tax. Anybody in Dayton? We have a really large tax department.
Okay.
Any follow-up questions?
No, thank you.
Just a clarification, you mentioned Don Motley is with a group called Focused Capital Solutions?
He's one of our attorneys as well with the law firm, but if you read his bio, we have a few ancillary companies that relate to government lobbying, working with legislative issues and different things like that. So he, in addition to being an attorney with the firm, also is a director with Focused Capital Solutions, which is a business affiliate providing government relations and public policy services out of our Columbus office, and it's out of our Cincinnati office.
All right. Any other follow-up? Next question, number 12. As a district, we depend on local property tax income and other sources to fund our operations. As our attorney, you may be called upon to examine the valuation claims of property owners and represent us as we challenge those claims. Please describe your experience with the County Board of Revisions, the Board of Tax Appeals, and the Common Pleas Court. Further, explain any additional experience you may have with this topic.
I can only talk about the people who are in here. That is not part of my area, as well as some of my partners here in Cincinnati. Tom Shuck being one has probably 35 to 40 years of experience working on these types of matters with the Board of Tax Appeals and bringing them all the way. I think some of his matters have gone all the way up to the Supreme Court of Ohio. Don Motley's another one, and we identified a few of his more successful, or very successful with the different results that he's gotten for clients, and he's handled these types of issues for the Board of Tax Appeals all the way into the court system as well. the big issue with these is determining with you, the board, the administration, and school district as when is the appropriate time, how do you want to do it, and what's the cost-benefit analysis of doing it for you. So that's where we would start with any of these, and where Tom, if he was the person doing it, or if there's anybody from our other offices, is, you know, if it's a no-brainer that we need it, that you've got to get in there, you know, we'll get in there and do it, but we're also not going to just run amok and every single time be the person that's challenging every valuation or challenging every appeal that comes up. You know, we want to work with you to identify, one, is it an opportunity that's not only just good for the school district, but it's also good for the community? Or is it a time where it may not be good for the community, for the school district to take such an active role? And that's the communication side between Taft and you that you would get. Because we don't act on our own without your direction, and we would want to understand that, you know, if you don't want a case by case, if you just want to say, here's what we're looking for, we've got paralegals plus Tom and Don who, you know, they're ready to roll on these, and they know all of the different regulatory agents as it goes from the bottom up. Any follow-up questions?
No, thank you.
I will have one that'll probably tie into after this next question, so I'll go ahead and read the next question. Assuring that all property owners pay their fair share of taxes to the school district is an important objective of the board. Tell us how our board should craft a policy that will properly guide our legal counsel as to how this objective should be reached. What input would you want from our board in developing this objective?
If I were doing this, and you're bringing me into an area that I don't do, the input I would want from the board is we would work very closely, and I would work very closely with the board to find it out and to define your objective, and then take that and then define the appropriate approach to go. As a firm, you would get the same. Don and Tom may have suggestions on the appropriate approach to take, and they can help guide you, but you are the ones guiding us, and you are the ones who are with the school district and who know, what it is you would be looking at, so therefore we would have to follow your direction to the extent that we can push you in another direction, we would if it seemed more appropriate for what you want. But it's a very collaborative process in working with attorneys at Taft. We don't like to just run a phone call.
No, it's his computer's acting up.
We're not looking just to get the work and run with it. We want to understand what the work is, what you want to achieve from it, and how we can achieve that for you.
No follow-up question.
My follow-up would kind of be a tie into the previous question also. You mentioned you would go on our guidance if we said, hey, the new shopping center, we think it's different than the valuation, and we'd like you to go after them. How could you make sure that we weren't cherry-picking some, which might give the impression of being unfair to not going after others?
Well, I think that we would have to do an assessment as to, either we would notice it over time by the ones that you were picking, or we would start it from the beginning as to, what is the mode that we're looking at to pick. And so if it's, business level, a certain size as this, we want to make sure that we're not going to be perceived as, going after one type after another. And that's what our attorneys will work with you. And they may say, well, hey, if you're going to do that, somebody may look at this a little differently and think that we're picking on this subset of group as opposed to applying this uniformly across the board. The other thing in dealing with it is we have tremendous relationships with appraisers, and we can call on those as part of the avenue of working with you as a board to determine when to do it, is to find out, are you running down a road that it's just not, it's not going to get you much. And we can tell you that at the beginning. I've got a client now who is working with our real estate group and Ed Diller and a couple others. He came with very significant questions. I do all of his company's work, but he came with very significant questions about the development that they're looking to do in St. Louis. And what we decided as a firm was, we'll do the legal work, but we knew the individual that could get him started on the right path who wasn't a lawyer. And so we're willing to defer that to the person so that you guys understand and you can use our connections to make sure on a valuation process, just because you think it's the right place to go after, that we can tell you early on if you're spending money to get nothing.
Okay.
Any follow-up?
We'll go on to our next question. Do you have anything? Okay. What options are available to the board about making records available that are not covered appropriately under the open meetings law.
It should be public records law is what it should.
Open records law or open? Are you talking about board meetings?
Well, there's other items such as financials or anything else that aren't necessarily restrained by the open meetings, by the public
Yeah.
meetings law. So I'll read the question again. What options are available to the board about making records available that are not covered appropriately under the open meetings law or public meetings law?
What's that question? I'm sorry.
I guess, let me ask you the question. Is it you want to make more information available that's not presently available based on your
Yes.
reading of the open meetings? I would tend to defer the discussion to Adam. Unfortunately, he's not here.
Okay.
But would indicate, that's something we would look at early on, if there's a way in which, you want to disclose certain information. There's information, obviously, social security numbers, things like that, you can't disclose, and you get yourself in a lot of trouble. And so we could talk about the areas and anything related to health insurance, health conduct, stuff like that. On the other side, we would look at what is the information that you're looking to disclose that you think would be beneficial to be made publicly available, what the goal you have behind making that publicly available, and who will that impact, and will that be a legal impact or more of a reputational impact? And that's what we would look at before you disclose that information. There could be other alternatives, and that would definitely be Mr. Miller.
Any follow-up?
Any follow-up?
Okay. We had two other questions we added at the last meeting. Number 15, how many school districts do you currently represent?
Do you know the number, Ryan? I think it's over 30, but some of these are, if you count charter schools. I think I'm looking at this list, it
It's about a dozen public schools, I think.
Some of these on this list, do you just do maybe board of revisions or just do
Correct.
certain things?
Yeah, there's some that we do everything for. Those would be Green, Stowe Monroe Falls, I think Northwest Clay, Cuyahoga Valley, no, that's not, that's Cleveland Metro, Labor Council, Cincinnati Public. I don't think we do everything for Dayton Public, but we have a significant amount of their work.
What do you guys do for Butler Tech? Because I'm on the Butler Tech board,
Where is Butler Tech?
Butler Tech Career Center.
Under Cuyahoga Community College on the road.
Right inside of it.
I know you said, I don't work with them. I don't, that might be something that Adam works on.
So the answer would be everything on page 5.
Everything on page 5, and I
Okay.
think we've added a few recently, but I don't want to disclose that yet because I don't think that they've been officially awarded.
Okay. And question, Bob, was there any follow-up?
No.
Okay. Question 16. Are there any hidden costs with your fees?
Hidden costs. Hopefully our fees have been, there are things that are excluded from the retainer. They're explicit as to what's been excluded. Excluded from the retainer would be the contract labor negotiations, CERB hearings, federal mediation, arbitration hearing preparation, arbitration hearings, state and federal litigation, as well as the Board of Tax Appeals and Board of Revisions. Those, I believe, are the only ones that are excluded. Now, that doesn't mean that there isn't, the opportunity to evaluate what charges would go with those. One of the difficult things with collective bargaining that we have and why we don't often put it into a flat fee proposal like this one is understanding what you need from us. We have some clients who they do most of the bargaining and we backstop it. We have other clients where we do all of the bargaining and therefore we have to be there and we're present and we're doing the negotiations. So on those, we get to know, we get to know you and a little bit about what your past spend has been. Not that we're looking to match that, to get a better understanding, and then we'll come to alternative proposals. For example, a lot of the clients I work with, will max out at 8 hours a day on collective bargaining. It could take 16 hours that day, but we bill for 8. The one thing you get too is we've reduced our hourly rates below our regular rates so that you know what the rate is, and it's not going to adjust for each bit of work. But as far as the day-to-day administrative and school board work that our attorneys do, and this includes, where the arbitrations and bargaining are outside, calling and consulting on employment relations, disciplinary issues, those are all within. And so people can feel comfortable to call and say there aren't going to be these hidden costs. We're not here to give you a proposal that isn't clear and understandable, but there are some things with each of these proposals that we have to move out and say this we can't put as part of the retention. However, over time, we could eventually adjust that. Same goes with state and federal litigation. If you find yourself in the unfortunate circumstance, I think we've got some of our attorneys.
I'd like to welcome the other law firm. We had asked the other firms to...
Sit outside. I just
okay.
wanted to set that in. Thanks.
Okay, thank you.
Can I follow up on regarding the costs? You have in here one of the items that are included in the retainer is attendance at student disciplinary hearings.
Correct.
Our current firm serves as our hearing officer for our expulsions.
Okay.
Would that
included?
that would be included?
Yeah.
Okay.
If it's not on the exclusion, as a good lawyer, I should tell you that it would be included. If it's included in there, that we specify in the exclusion, because we don't go into great detail on special education, but that is certainly included. All those issues within the retainer.
All right. Thank you.
And just for clarification, any idea how many of those we have?
Well, we hire another gentleman who's not an attorney to be the hearing officer for about half of them. The other half, gosh, I don't know the number, but I would give you a rough estimate. There's probably 150 to 200 hours a year in terms of that. It's 1 day a week, probably about 4 hours, approximately.
We've had.
Yeah.
Is that so? We had about 200 hours last year.
That's just a rough estimate.
We might have had a different year this past year also, but
This year was probably more than that.
we have a new superintendent for the past year. Was there any other follow-up questions?
No.
And that was all of our questions. You have about 15 minutes left if you have anything else you would like to say.
Well, it's not necessarily I'd like to say. I've got some questions for you, if that's all right. Because I read that the contract with your current firm, continued on for a few years. What has prompted you to go into that contract and start looking at other firms?
Change in the board.
Honesty is all we want.
I would say direct that question to the three gentlemen to my right.
I'll ask a follow-up question to that, because it's not to be a controversial question, is, what are you looking at in the relationship with a lawyer, or really with any vendor, that the board has to have direct dealings with?
We did our search a year ago for our attorneys. We went through this whole thing a year ago. And when Michael and Chris got on the board, Dan, they wanted to do another search. So that's why we're here.
So we're not really sure what they're looking for.
We have had for many, many years, we've had the same firm, and not just law firm, but some other vendors also. And with the new members on the board, just to try to improve things in the district, we're looking around at the different vendors that we have to try to hopefully put things on an even better path than we're on.
What are some of the factors, and again, you don't have to disclose all of this, I won't tell any of the other folks. What are some of the factors, even for those of you who did this a year ago, that were important to you then, that would still be important to you now, and for those of you doing it now, that would be important going forward, that your lawyers and other vendors would want to know, is like how to be able to work together and work together in good enough.
I think it's important to have the most school law experience possible. I mean, across the board, not just maybe be strong in one area, but I mean, we're the second largest school district in Hamilton County. We need to make sure our attorneys can, cover everything. And to be honest, as board members, I don't even think the 5 of us really know on a day-to-day basis what all we use our attorneys for. Typically, it'd probably be more important to see what our team needs and what they use the attorneys for. And then special ed is a big thing. I mean,
Well, the big areas that we use, one is Board of Revision matters, we use that, but special ed law, student services and student discipline, and then human resources are the big 3 areas. So we're looking for someone, I'm looking for someone that has experience in that, but then also accessibility. That's important to us as well. Someone that's in terms of location, and when we call, we'll get an answer quickly. Typically when we're trying to get, unless it's some sort of scheduled meeting to come up with an MOU or a collective bargaining agreement, other calls typically need to be answered quickly because it's something that, when you're trying to get hold of your attorney, it's typically not a good thing. So we want to make sure we have a good response time and access to them.
The thing that I personally am looking for is a firm that is very detail-oriented, firm that files everything when it's supposed to be filed, whether it be a contract issue with CERB. Somebody, as Dr. Jackson referred to, that gets back quickly, is accessible. I am, again, as Pam said, I'm not a lawyer, none of us are, but I think that somebody who also, that at least I can, just as far as I'm concerned, somebody who might approach, we have a lot of frivolous lawsuits. We had one when I was on the board earlier some years ago where a young child got hurt in a gym incident, and I think we voted 4-1 that we not settle that because the kid was fine until he went home, and then the family, put him in the slings and all that stuff, and then threatened a lawsuit. And then we had family members of the gentleman calling saying this guy is a scammer. He's filed bankruptcy twice, but yet we still settle. So, that sort of thing.
I think in responding to some of those comments, the one thing that we can provide, and we do have the depth of school law experience across the board. You just managed to not get the school law lawyers here tonight. If you hold that against us, we understand. One of the issues we've discovered where we've got the variety we serve in certain areas is this has happened more in the colleges and universities, and it's starting to happen a little bit more in the school districts. Is college and university law used to sort of be its own subset from the private side and the public side. Now they are big businesses. These are the largest employers in their regions typically. These are people that have the same human resources issues as GE down the road and other folks. And so that's where we were able to translate for those folks to say we can bring that very detailed and practical aspect. Accessibility, one thing, you get all of our cell phone numbers. Besides email, cell phone, my wife will tell you I'm constantly accessible. I know that Adam, even, he's been bouncing back and forth things as he's on the JAG duty before tonight to get things. That is something we find is very important. There are plenty of people in the Cincinnati office, and Dayton's just 45 minutes away as well, me being one of the Cincinnati folks, that if you need somebody here, we can get somebody here. You've got one of the deepest benches that if it's not me, it's going to be somebody that I trust, and that I think will be somebody that you trust, and that we trust as a firm to come out and represent us. Because everybody we bring into our firm, we expect that they may have to cover for us at some point. Adam, I can tell you, I don't know how many miles he puts on his car, but it's a lot. And he will be here. And he, some of the other school districts we represent, I don't know if you are like them, but they've got the meetings that go until midnight, 1 o'clock in the morning, and then he's got a 2-hour drive home if he has to get up and be somewhere, at the Ohio Department of Education the next day. So those are things that we pride ourselves on. When I started practicing, the managing partner had told me, when you set an expectation, the main thing is to follow it. It drives me insane if people don't file things at the right time. On issues with frivolous litigation, anybody who gets sued automatically tells me that they've just been sued and it's frivolous. One of the things that I can talk with you about is finding out if it is, and then when settlement's appropriate and when settlement isn't appropriate. And those are hard decisions to make, because sometimes you do end up settling a case. There was just no reason to settle it, but there may have been a business reason to settle it at that point. And that's what we walk through. And so and those are hard discussions. I said I came from another meeting to get to this one. They're involved in what they think is the world's largest frivolous case that's ever existed. Problem is, it's a lot of time and a lot of effort and energy, and we've got one side who wants the world, and my client who doesn't want to give them anything. So today we're sitting there discussing what's our strategy moving forward. We kind of thought these people would just go away. In my opinion, it might be a frivolous case, but they've got enough to at least keep it in the courts. So those are things that I can assure you would get. We've had to work very closely, and with boards, here you got the board and the administration. You've got 10 different personalities. That is one of the great things about working with a board. One of the proud moments of my career, and I don't know if any of you guys, you may have seen it on the list, as I said, I was general counsel for the Cincinnati College of Mortuary Science. I got that position when it was at its bottom point, which people would not know because nobody writes articles about that. But there were financial problems. There was federal funding problems because student financial aid had been messed up. There were professor problems and professors having inappropriate, being alleged to have inappropriate contact with the students. Now this is at the college level, so it becomes a little different. There was an administration problem with somebody running in who, should not have been in that position. And I was actually brought in just to bring in a different firm because they were so wed to the other firm who've been their lawyers for years to help them guide through some significant personnel issues that they needed guidance on. And unfortunately for the people we had to take and move on, they had to go do something else. But for the school, it ended up from that where they displaced the other firm and brought our firm in as their permanent general counsel. And then as it was still near the bottom point, I had to go sit there, a couple days a week and do my work for the firm because they didn't have a president or an administrator on site. And so they said, let's bring the lawyer and the accountant and other people just to manage the situation. We managed to bring in an interim president who got us back up to speed financially and brought in another president who's turned out to be phenomenal. And sitting yesterday at the Kentucky, the Funeral Directors Association of Kentucky with the board chair who brought me down there to speak, it was one of the proud moments of my career. As he and I were just talking, that at one point 2 years ago, they had a totally dysfunctional board that spent most of their time yelling at each other. They had an administration who could not work together. And now they have, and they didn't change over the board. There was only a couple people who were term limited off. Now it's almost like a sigh of relief, but the value proposition when we walk in, the people are all working together to the same end. And the school has a vibrancy about it. I don't know how, but now we have more students suddenly. You may get more people and more neighborhoods built up here to get more students, but it went from once being known as the Harvard of mortuary schools, which is true, to students not willing to even give their money there because they didn't know what they were going to get as an educational experience. Now to being back on top, all in a 3-year time frame.
Well, thank you. I didn't get to weigh in earlier. I would second a lot of that about detail and accessibility, knowledgeable. I think in a perfect world we would have like an in-house counsel here, but that's probably not very realistic at this point. And so I just really think when you have that, you have all of the other traits that have been articulated. But I did enjoy that. With that in mind, I didn't appreciate that experience you just related with the Cincinnati College of Mortuary Science.
And you probably do need an in-house counsel at some point, but budgets don't always allow for that. As the second largest district in Hamilton County, I'd say someday it'll be on your plate to figure out. If you don't have any other questions for us, thank you. Again, we appreciate the opportunity. I would have loved to have known more about what I was walking into, but this was quite an experience.
You did quite well, and thank you for being here.
Thank you for your time.
And we're going to, our next, we'll start at the 5-minute recess, and we'll come back at 7:25 with the next firm. I said we'd start back up at 7:25. Is all of your folks here, Mr. Dieters?
Yes, they are, Mr. Anders.
And I would like to mention that that with the previous interviews, if there's anyone from the, I guess the one we haven't heard from yet is Brickler and Eckler. So if there's somebody in the room from Brickler and Eckler, this is an open meeting, but if it would be all right if you could step out of the room because we don't want to let you hear the questions in advance. So I guess no one else is here from Brickler and Eckler. Okay, so our format has been you have an hour, and you can talk about your firm or whatever you want to do with your hour, but we do have 16 questions we've prepared, so please try to allow us a little bit of time to ask the questions.
Certainly, absolutely. Okay.
Hi. So we'll start at 7:28.
Okay, well, thank you, Mr. President and Board. First of all, I think most of you know who I am, but I'm Bill Dieters with Dennis Robertson Fisher. I have with me today Mr. Mike Fisher, one of the founding partners of our firm, Aaron Wessendorf, one of our attorneys in our office, Jeremy Neff, another attorney in our office, does a lot of special education work for you, my partner, Bronston McCord, and another one of our associates, Ryan LaFlamme, that's standing right back behind him. We wanted to have everybody here today, but we had a couple other people that had previous engagements to some board meetings and a few other things around the area, so they weren't able to make it. But we did want to ensure that we had a good presence here for you today. I'll be fairly brief, I believe, or I'll try to be for as much as I can be. As those of you know me, sometimes I talk a little bit too much. But I'm going to refer to our firm as ERF, Ennis Robertson Fisher. First and foremost, I believe and I know that Ennis Robertson Fisher is probably the first and longest standing school law firm in the state of Ohio that is solely dedicated to the interest and focus of representing public boards of education. There are other firms that may have been around longer than us, but none that solely focus on that aspect of law. We're kind of a one-trick pony. We deal with schools and boards of education and focus our 90% of our representation on that issue. You're not going to find us to have conflicts with other issues, conflicts with other clients, conflicts with other corporations, and you're never going to find us in any capacity going battle against another school district unless it's something that we can't avoid because one of our clients needs to engage in litigation maybe against another client somewhere in the state. But it would never be something that we would take up on our own. Okay. Ennis Robertson Fisher probably has over 100 years combined experience of everybody in our firm out of our 8 attorneys in the representation of public school districts and public entities related to school districts. So there's a vast amount of experience. We have 8 attorneys, we have 3 partners, we have 4 associate attorneys, and 1 of counsel, Mr. Fisher. Of counsel, we obviously was a previous partner and previous founder of our firm. We were established sometime around 1975, and we've been representing Northwest School District since 1977. During that time, I've worked with 6 different superintendents, more board members than I probably can count, and more administrators than I can count. And Mr. Fisher was naming some names. He remembers when Mr. Hester was the superintendent. So that's how long we've been working with you. I think sometimes people think just because you've worked with a vendor for a long time or a service for a long time that, do we rest on our laurels or do we not provide an equivalent service or the adequate service that you need? Well, I don't think that's the case here with Ennis Robertson Fisher and the school board. Twice in the last 3 years, we've gone through the same process for request for proposals. Did the same thing we're doing here today, and twice in the last 3 years, we were determined to be the best firm to represent your needs. We think we provide premier value to our clients, and we think we support their desired outcomes in a tremendous way. We are well respected throughout the state of Ohio. I don't think you're going to talk to anybody that does this for a living, whether they're competitors of ours, whether for people we represent, or whether people we don't represent, about who we are and what we do. We're very well connected with the Ohio School Board Association. Just recently spoke at the Board Leadership Institute. Our attorneys probably speak at, I can't even name, more than 20 opportunities a year probably, in combination between the Ohio School Board Association, VASA, the Ohio Association of Professional HR People. I am the current president and chair of the Ohio State Bar Association Educational Law Committee. Mr. Stedronsky, who's one of our other partners, is currently on the executive committee of the Ohio Council of School Board Attorneys, which is an OSBA affiliation. I'm past chairman and president of that organization. Mr. McCord is past president and chairman of that organization. And like I said, Gary currently serves on that organization. I'm also honored to be part of a very small select group of special education attorneys in the state of Ohio that meets once a quarter with representatives from the Ohio Department of Education. And we talk about problems and issues that our clients are having as it relates to the Department of Education and their ability to serve our clients in the special education world. Sitting on that committee is also representatives, the Chief Legal Counsel, the Chief of Special Education for the Department of Education, and the attorney that specifically is an Ohio Attorney General attorney who is assigned to the Department of Education related to special education needs. One of the unique things about our firm is our approach to our representation. We are very proactive. We have enough clients that we don't need to burn our clients dry. We don't need to suck our clients dry with work. We would much rather have you work with us in a preventive maintenance way through training, through education, through getting your people to do the right things first. Do we make less money when we do that? Absolutely. But in the long run, you are kept out of trouble. We make more money when our clients get in trouble. Let's face it, we do. Litigation is long, it's costly, it takes a lot of time. We don't need that in Robertson Fisher. Our goal is to provide value to you, for your taxpayers to have protection to keep them out of trouble. We have probably given, and I am not exaggerating here, well over 100 hours of instruction and seminars in this area alone in the last 12 months, free of charge to our clients as part of our services. We have an administrators academy that happens 4 times a year. That's 3 to 4 hours each academy. We have Ashland service credit for administrators that go to it. We do countless webinars. Something comes up that pops up, it's a hot issue, we'll do a webinar on it if we can't get people together. We have a blog that comes out whenever a hot issue happens. We have a monthly newsletter that we give to our clients. And there's many, many other things. Myself and Pam Weiss in my office did a presentation, 6 of them, in Cleveland, Columbus, and Cincinnati, one on OTES and one on OPES, which is the principal evaluation system, in Columbus, Cleveland, and Cincinnati. Probably had over 600 people attend in those 6 sessions, free of charge. Gave back to our clients to say, hey, look, this is an important issue. We think it's an important issue. We want to give back to the people who support us and have been so good to us for years. We want to do that back. We've been published in the OSBA Journal. We've been just recently published in the Ohio State Bar Association Journal. And in fact, Jeremy and I kind of laughed about it, but numerous publications picked us up throughout the state of Ohio on a recent article we wrote regarding the obligation to report child abuse in schools. So I think we're well respected, and that history of how we represent it and work with this district and our approach to legal services has been consistent. And I'm sure if you ask your administrators, they will tell you we're always there. We're the first ones there if we can. We strive to be the first ones to help them and be on the cutting edge of the things they need to know. We are problem solvers. My kids, when they were young, didn't know what being an attorney was, when they were 3 and 4 and 5. And I said, Daddy, what do you do for a living? And I said, well, how are you going to explain that to a 4-year-old kid? So I said, you know what, I think at the end of the day, Alex, we help people solve problems. And that is truly what we do. You call us and we want to solve that problem. We want to be part of your solution. If you've worked with me before, whether it's collective bargaining, whether it's a meeting, whether you call me on the phone, you will hear me use the pronoun we all the time. And we believe at that at Robertson Fisher. We're part of your team. We're not just some vendor that's coming in here, fly by night, want to make some money on our client. We want to be part of your success. We want to be part of the success of public education in the state of Ohio. And that's why we give back the way we do. A little bit about our fees, our value. Like I said, many of these things are done for free of charge. But we also, I think, have a competitive rate in the market. We're not the cheapest. We're not the most expensive. We're very competitive. But don't ask an attorney what they charge an hour, because that's not the real charge. The charge is what does it actually cost for the service. And one of the benefits, you call anybody in our office, the 8 of us in our office, and chances are, because that's what we do day in and day out, we can answer that question faster and more efficiently and with better level of experience than anybody out there. I don't even think it took me 7 minutes to drive here today from our office. We're right down the road. Frequently, we'll get calls from your administration, hey, I need somebody right away. I didn't think I was going to need somebody. Can someone get down here? We throw on a suit, we throw on a tie, and we get there. Northwest is one of our most important clients. And I'm not telling you that because I'm here today, and I'm not telling you because of all the shenanigans about this. I'm telling you that because it's true. And it has been for almost 4 years. That this is a very important client to our organization. And when you guys call, you get first billing. And I'll be honest, I'll be blunt as I can be with you. We look at, every 12 months, we look at the clients that have used us the most. And those people are going to get our top, just like any business would. And they get our top level of service. And you're right there. You're always right there. You're always in that top 3 to 4 or 5. And we think we've been part of your success. You're not going to see 2 attorneys come. These guys will tell you, we don't bring 2 attorneys to a meeting. We don't bring me and a bag person to hold the bag, because that's just billing you more money. And in fact, I don't usually even bill you for travel very often if I'm coming over here, because it's 10 minutes away. So I hope that you understand the value that your organization gets from utilizing us and the expertise we have available in that process. We have, I think, a retainer agreement that your district has been very valuable to your district for a very small fee. I think, what is it, about $250 roughly? Roughly $250 a month. You get access to all the things I just talked about. The blog, the website, the webinars, the free seminars, all of that you get access to for that money. You also get access to the ability for your administrators and you as board members to call us, and if there's simple questions, need a quick answer on something that I would expect that you would expect that I would know as a school law attorney, and I would expect the people that work with me and for me would know, and that we can answer those questions quickly on the fly, and we don't bill you for those. In fact, we don't even track it. It would take us more money and time and value to track how many times we do that for you than it would actually be that we'd actually make on it. Okay, so that's another way that we want to pay back. Okay. We have practice areas. We have attorneys that concentrate on certain areas. We have attorneys that practice on the needs of treasurers, the needs of tax people, finance people. We have ones that concentrate on the needs of special ed people. We have attorneys that concentrate on building and facility issues. All of us have a vast experience in labor law and collective bargaining, and all of us have a vast level of experience in all the needs you have related to your students' needs and rights. But we've determined that construction law is a little specialized. We need to have somebody that kind of knows a little bit more. Special education law, by its very nature of term, special, and there's a lot of counterintuitive things in that. So we've really tried to look at our practice continuously to be improved. We've sent out 2 surveys in the last 3 years to our clients and said, hey, how are we doing? If we're screwing something up, if we're not doing something the way you need it done, talk to us, tell us about it. We'll make some changes. And we've learned a lot in that process. We've learned that we need to improve things over time, and we've done that. We've also learned that some of the things that we were doing that we didn't think were valued very much by our clients were highly valued, like the newsletter and some of the training that we did. So we focused more energy and more efforts on those. So we're not perfect. We never said we were perfect, but we're good, and we listen to our clients' needs, and we do the best we can and strive to be part of their success. And we have, our track record speaks for itself. I don't think there's anything that we've touched or done in this district in the time that I've worked with you for almost 20 years that I would regret in 1 second or believe that something was done wrong or bad advice was given. We have had tremendous successes, and so many that we'd be here for an hour if I went down the list of what we've done for you in the past. And I'm proud of that, and our firm's proud of that. And we want to continue that representation, and we think the taxpayers of this school district have benefited greatly. You also, I think, have this inherent benefit, and I always joke around with some of my people I work with. I'm a West Sider. I grew up on this side of town. I know intricately how the culture is on the west side of town. And so did Aaron. The rest of them, they weren't so fortunate. But this is, I kind of joke around. You're my people. I grew up over here. And the families and the names and that come across my desk when I'm working with Northwest are the ones that I've known for a long time. And so we're proud of our representation. We want to maintain that. Probably what I want to kind of say, here at the end is you're not going to find a firm that approaches legal services and representation of schools like we do. We're unique. And I always, some of you know my secretary, Barb. And Barb and I worked together for a long time. And my colleagues we kind of have a love-hate relationship. We love each other, we hate each other, we love each other. And I'm hard on her, and she's great. She's a great lady. When she came to work for us, after about 7 months of working for us, she said, Bill, I can't believe it. I go, what do you mean? Because she had worked in law firms throughout her whole life. She says, you guys spoil your clients. I said, what do you mean? That's what you're supposed to do. She said, no. The way you guys treat your clients and their expectations, they are out of this world. It's unreasonable for them to think that you're going to do the things you do for them. And we said, that's how we do it. We don't know any different. We're a service business, and we serve. So we're happy to answer any questions. I don't know, Mike or Bronson, if any of you guys have anything you want to say related to it. You guys know who we are. You know who we are. And you're going to keep getting the same thing. And if we're not doing something you want us to do, or you need us to improve on something, then you need to let us know. But to this day, as I stand here now, I haven't heard that from anyone. And so if you're looking to move for the sake of moving, I can't do anything about that. But if you're looking to continue the success that this district has had and the relationship they've had with us, then we're your guys and people and girls. We're going to get the job done. And we always have and we always will. So any questions you have, we'll be happy to answer them.
Could you take to the mic, please?
Oh, okay.
I can say without, as a transportation without fear of contradiction that Intertraffic officials for the past 37 years have provided legal services supports of education that are at least equal to, and in most cases better than any other law firm providing such services in Ohio, and at a cost significantly less than what any other firm would charge their clients. We've represented Northwest for, Bill says, almost 35 years. I participated in that representation for a number of years, still do on occasion. Northwest has benefited from Henderson Roberts Fisher negotiating all of your collective bargaining agreements. Those collective bargaining agreements have protected and maintained your ability to operate your educational program the way you see fit, and have done so without causing any labor unrest. I have represented Northwest in a number of special education matters. No attorney in Ohio would have more experience in special ed than I do, because I've been doing this since the IGA was enacted. We have virtually always been able to resolve any disputes with the parents amicably or without going through process. The times that we had to go through the process is because the parent was unreasonable and there was no way to reconcile it, but every time we went to due process, we were successful. Northwest prevailed. And the Board of Revision matters, and Charles Fisher has retained over $500,000 of tax money for the district every year. I would simply suggest to you that you're looking for competent legal services at a fair rate. You're looking for a firm who can provide you all the legal standards in a cost-efficient manner.
I will go ahead and start with the questions.
That would be great.
Okay.
And what I'll probably do, Mr. Unger, is I'll field them at first, and then if there's somebody that I think I need to phone a friend or something, I got a good team behind me, so that's why they're here. So.
Okay. And I think somebody has an open mic that's writing down something, because I hear it going through the sound system. So, okay, we'll just jump right in. Human resources, question 1. Explain the differences between the current law for OTES, OPES, and recent changes to that legislation.
Oh, how many hours you got?
Well, you've got about 40 minutes left.
Well,
so.
Like I said in my opening statements, our firm partnered with a firm out of Cleveland called Britton, Smith, Khalil, Peters, something, and we went on a tour throughout the state of Ohio, a barnstorm, and went out there, and the policy that probably significant majority of school districts in the state of Ohio have is a policy that I wrote with help from my colleagues. The policy that Neola has on its books right now for OTES is a policy that I wrote. The OTES is an evaluation system that's based on 2 components. It has a student growth measure component and has a teacher performance component. The teacher performance component is not much different than what we've always done in the past. We've changed some of the names, some of the wording, and some of the rubrics, but observing teachers in the classroom and looking and evaluating their ability to instruct students in good teaching techniques and all the things that I learned over the years about differentiated instruction and whether or not they're letting kids participate, how they're letting them participate. That's something we've always done. The new part of this is that we're going to measure how kids grow, how do teachers stretch kids in the classroom. And that's the student growth measure point. And that's the point that has value-added scores for those teachers in certain places where state assessments are available. That's the student learning objectives and those kind of things that are done in places that aren't. Difficulty with OTES right now, in my opinion, is that the data is new, doesn't have a lot of validity yet in the testing process. And if you talk to the experts in Battelle in those places, they'll tell you until you have trend data available, that it's not really all that beneficial to look at and how someone's doing. If you look at 1 year at a time, it's not a good snapshot. Look at how a teacher's doing over time, then you can really determine whether or not they've been effective in the classroom. And it's a game changer for teachers. We used to evaluate teachers based on achievement, not on growth. Now we look at growth, which is a whole different issue. And so we have been very instrumental in working at the bargaining table to ensure that we put things in place that protect your board policy, which we also wrote, and I wrote, and to allow you to have the management flexibility and right to evaluate teachers and to help teachers improve and make them better instructors. But it also very clearly provides the ability for us to get rid of teachers if they're not doing a good job. And it's in a memorandum of understanding that's attached to your collective bargaining agreement. It's part of our process. Now, we still have the old evaluation system, and that's still in your contract because those teachers who do not spend 50% or more of their time in student instruction are not covered under OPES. And OPES, the great thing about that right now is that for the first time ever, we're going to look at principal evaluation, and we're going to connect those to those teacher evaluations. So those principals now have a vested interest in ensuring that they improve the quality of instruction in teachers in the classroom, because their own evaluation now will be based on how their teachers perform and how their students perform in their building. And I tell boards of education all the time, in 2 or 3 years from now, when Dr. Jackson comes to you and says, I'm going to recommend Bill Dieters for a new contract for a principal, you should be asking him, what are Bill Dieters' student growth measure scores in his building? And no matter how good everybody thinks Bill Dieters might be as a principal, if his growth measure scores are not where they need to be, and there's no adequate explanation as to why they shouldn't, then you should be challenging your administration as to why should we give that person a new contract. So it's truly, I think, a game changer, but it's going to take some time. And we've got to be a little bit patient to make sure we get it put into the right place and that we truly understand and be fair about the fact that they're being evaluated under a new system. There have been some recent changes to it. I'm not sure if you're referring to that, Mr. President, but House Bill 362 recently made some changes. They changed some of the timelines for accomplished teachers. They provided the ability to kind of change some of the breakdown between student growth measure scores and how much of it had to be part of the evaluation, and it allowed you to go a little bit lower if you did some surveys and did some other kinds of things. It's a lot of details that probably aren't worth talking about here today, but it's something very important. And if you went to my presentations, or anybody that did, I said boards of education cannot give up this right, because when OTES went into place and they changed the law, they put the responsibility and the obligation for teacher evaluations on the 5 of you, because it's a board policy now. It's not something else, so it's your responsibility to ensure that it's done. Anything on that? Okay.
So that you're in control of your time, what we've done with the other interviewees is allowed you to ask if any of the folks up here at the table have any follow-up questions, but that way you're in control of the process.
Yeah, I don't know if anybody have anything else about that at all. I don't know. I mean, we worked very closely with Dr. Jackson and with Tracy and Greg when Greg was still here, and we were probably one of the first ones on the front end of that OTES issue, and it was done very smoothly in collaboration with your teachers union. They came on board with us, and I think you got a really good plan in place here right now. Now it's going to require us to continually modify it and look at it over time, but you're in a good position right now.
Okay. We'll move on with the second question. Have you reviewed our Northwest Local School District labor contracts? What are your comments about the contract provisions?
I have never seen them before.
Okay, question 3. Go ahead.
You know, I don't know. Sometimes when I do this, I have a hard time. They probably would disagree with this, but I have a hard time sometimes trying to toot my own horn on these things, but I'm going to do it. I'll put your teacher's contract up against anybody. I don't care who it is. Because you have something in about the first 3 pages that is like the kryptonite in negotiations. You have ultimate impasse implementation language. And if anybody looked at your contract, if any attorney sat up here and didn't notice that and tell you that, then they don't know what they're talking about. Because that language allows you, if you get to an impasse with your teachers and you get there under good faith bargaining, you got to do some things to get there right. If you get there the right way and you get into an impasse, you have the right to implement your final and last offer. There's only 3 contracts in the state that I know of that have that. Mike might know of a couple others because he did this. He knows he's forgotten more about this than I've ever known. But I know I worked with it here, and I bargained it into both Lakota contracts. And so that's almost all you need to know. But I'll go further. You have loser pays for arbitration. You win, they lose, they pay the arbitrator. You have an arbitration panel. A lot of contracts don't have that. The 3 arbitrators on that panel are all very fair, very good arbitrators, and we're not just rolling the roulette wheel every time we have an arbitration and not knowing who we're going to have. You have blended learning language, cutting edge right now, that allows you to do things with blended learning and have super large class sizes that other people don't have. You know, Andrew and Rick were on the front end of getting that done, and they got it done, and we got blended learning language. You have personal leave restrictions, time and place personal leave restrictions that make it manageable for you to manage personally so you don't have 1 million people gone in the month of May fighting for subs. you have transfer and vacancy language that gives Tracy's office and Todd's office some unbelievable flexibility in how they want to transfer teachers. In fact, we've had, I think, 2, maybe 3 arbitrations in the last 2 years where they try to challenge us on it, and we beat them down all 3 times. So, yeah, you have a great contract. But you also have a great relationship with your union. And that is, to me, is just as important. You have a very collaborative working relationship with your both unions. You work together to solve problems. We don't fight, we don't bicker. We do what's right for kids, and we do what's right for the organization. So having said you have great employment contracts, you do. But I'm not going to sit up here and say that you don't have a great relationship with your unions. You do. And that is an absolute positive, and that is a testament to the work that's been done by this administration, past administrations, by me, by people who have represented you in my firm before that. And you can't discount that, because the contract's one thing, but sometimes you just need to get problem solved, and you've got a great union to get that done. They work with you. Okay? Any other questions? Well, you also have the ability for a superintendent to suspend a teacher for 20 days, which is not in the law. So.
Just one quick follow-up. How long has that ultimate impasse language been in that contract? I figure that's...
I think George Roberts got it in the very first contract, Mr. President.
So probably before my time and way...
And every single time,
probably
they
when
have
Ohio...
tried.
Right after 1984, probably right after 1984, because in 1984 was when the collective bargaining...
Right, or 83, 84.
So sometime in that 84, Robbie and I were both for
I've always wondered that. Okay.
But a couple things about that. One is they this last time, they've almost given up now trying to get it out. But they've tried to get it out many, many, many times. And then the other thing is we did utilize it one time. I don't know if you remember when we had the insurance crisis and we had I can't remember how 35% increase or something crazy like that 4 years ago. And we had a pretty long, drawn-out negotiations, and it got pretty heated. And obviously, I understand the teachers were going to have to take a big concession on health care. And the only reason, in my opinion, you got the HSA, high deductible plan, and the only reason you got the language that you have, and don't forget this, you have some pretty unique language that if your premiums go up a certain amount, they either eat the difference or they come back to the table and they make a change to the plan. That language and the HSA language would have not been possible, in my opinion, without the impasse language, and I firmly believe that.
Okay, we'll move right on to the next question. What is your approach to labor negotiations? How will you help to advocate on behalf of our board?
Well, I think I kind of talked a little bit about our approach. I mean, our approach is that we're not pushovers, and we want to advocate for strong management rights, but we also understand that having a good working relationship and treating people fairly is part of the process. So we strive to balance that through the process. When I bargain, all I have is my integrity. All I have is my word. And I will tell you unequivocally that not every OEA rep loves me or likes me, but they all respect me and they all trust me. And that goes a long way to negotiations. And we have to work with these people day in and day out. I just had a conversation with one of our associates today. We have a trial tomorrow. And Erin was quite upset with the behavior of the attorney on the other side. And she says, well, I'm not used to this because not all of our attorneys that we work with act this way. And it happens to be one of our we only have a few private clients, and we took on a private school on a small issue. And I said, well, the difference is the other attorneys that we work with have to work with us over and over and over again. And we have to work with them over and over again. And so we have to trust each other, and we have to treat each other professionally. When you work with someone on a one-off, they don't have to treat you that way because they don't care about you. So our approach is proactive. Our approach is, we've always done here, we prepare, we get data, we find out where your 5-year forecast is, we find out what the important issues are for your administrators. We bring to the table the issues that we think are important, like right now this year, reduction in force language, OTES language, issues related to the change from days to hours and how that impacts your calendar and your language, and ensure that there's nothing in your contract that's going to prevent you from doing that. So it's a comprehensive approach, totality of the circumstances, and it's 80% preparation prior to the negotiations and 20% execution during the negotiations.
It's up to you to ask for follow-up questions.
Any follow-up?
Okay.
I don't know.
Okay. We'll go on to the next one. Discuss your experience negotiating collective bargaining agreements with a teachers union, with a teachers association represented by OEA, or a bus driver association represented by Ohio Association of Public School Employees.
Well, the experience I have is I've probably negotiated well over 400 contracts, and some combination of teachers and bus drivers or classified or whatever it might be. Mike, I don't even know how many you've probably done. Bronson's probably, I mean, I've probably done, I'll end up doing probably 22 or 23 just this year. So, I mean, that's what we do. I mean, negotiations is our bread and butter. I mean, that's the lion's share of our work that we do for clients. And it's the other things that deal with negotiations. It's the grievance issues, it's the problem solving, it's the midterm bargaining after the negotiation happens when something comes up in the middle. So you're not going to find a firm that has more experience in negotiating bargaining agreements. And Mike actually also was, before he became a school law attorney, he worked for the National Labor Relations Board as a staff attorney there. So we have the old Sage and the Oracle we can go to as well sometimes when we get stuck. So there's nobody else that has more experience than us, I don't think. So, any questions about that? Okay.
Moving into student services special education. Explain the difference between school law and civil law as it pertains to student disciplinary hearings.
When you say civil law, I'm not sure what you mean by that. Possibly you mean criminal law?
Yeah, I think it's actually criminal law is what we're referring to.
Well, you know, it's an interesting thing because when we go to a student expulsion hearing or appeal, you know, a lot of times the attorney on the other side is just, you know, someone who's a family law attorney or a general practitioner in the community, and the parents want an attorney because they're mad at the district and they want to get their kid back in school, so they go see an attorney, and the attorney walks into the expulsion hearing thinking they're going to court. They think they're going to court like defending a criminal defendant, and it's very different. First and foremost, like, you know, on a search and seizure under the Fourth Amendment, the standard for a search, an unreasonable search under the Fourth Amendment for a police officer is probable cause. For an administrator, it's reasonable suspicion. Significantly different standards. I mean, night and day, 360 standards. There's a lot of flexibility. The level of due process is very different. The due process for a 10-day suspension is nothing more than having the student appear before the principal and be told what the charge is and asked to give their opinion as to whether or not they're guilty of it or not. A little bit of a heightened level of due process under an expulsion because they have the right to have their parents there. But there really is not a right to cross-examine witnesses. There's not a right to, you don't have to swear people in those kind of hearings. Sometimes it's advisable to do so. Sometimes there can be strategic reasons to do so if you think you definitely know what's going to court, but you're not required to do it. You know, and under the criminal law, you have a right to confront your accusers. Well, I think, Mike, you worked on the Batavia case, the Newsom case. Mike had a case that's quoted all over the country. I'm not exaggerating. It is the seminal case in the entire country on whether or not you have a right to know who your informant is if there's an informant in a situation at school. So somebody says Diederik is dealing drugs. I want to know who did it. I want to cross-examine them. We don't have to tell them. There was a follow-up case out of Iowa from Mike's case in Batavia where they said not only do you not have to give the names, but you don't have to give written statements. And then there was another follow-up case after that said you don't even have to give the teachers' names. So it's vastly different. And if you don't know those things and you don't live that stuff every single day, then you're doing a disservice to your client if you're presiding with them or for them in a student expulsion appeal or student suspension appeal matter. It's much different. It's very counterintuitive and it's very different than the law. But we know, the courts have said students don't shed their constitutional rights when they walk through the door. But those rights are modified. And in some respect, they're modified substantially. And you have to know. And sometimes they're not. We'll get calls sometimes from clients that say, well, I want to make this stop. And we'll say, well, you really can't because that student has a First Amendment right to do that. So you may remember the Vietnam case where the students were wearing the black armbands. And the school didn't want them to wear them, but it wasn't disruptive. And the court said they had a First Amendment right to do it. So there's a lot of differences when it relates to those issues. And we know them as well as anyone. I'm not looking at any notes. I'm telling you what I know off the top of my head. And that's what we know. And those are the kind of answers you get when you call our office. We know that stuff. We know cold. Just like these people know their job's cold. I call them and start asking them about differentiated instruction and those kind of educational things. That's what they do. And that's what we do. So, any questions?
One real quick one. Have you ever been called, you mentioned family attorneys and families bringing in a family attorney to defend against an expulsion?
Yeah.
Has your firm ever been called by a family and maybe brought you to a district that wasn't
We
us?
wouldn't do it.
You wouldn't do it? Okay,
No.
that was my question.
Yeah,
Haven't called many times
yeah,
because we're going to school,
Right.
so we do get calls from parents.
yeah.
But we always.
You won't take that case? Okay.
We'll get in that one. We'll do our job as an officer of the court, though. If you called me, I wouldn't say, no, I wouldn't do it, hang up on you, say, no, I'm sorry, Dan, I couldn't do it, but I'll recommend somebody for you.
Okay. Yeah, I don't want to get in
Yeah.
your time here, so I'll go on to the next question. That's an interesting answer, though.
Yeah.
Explain the relationship between IDEA services and 504. Define each term and the characteristics required for qualification under each category. If special education disputes do arise, how will you help to amicably resolve the disputes and help to avoid unnecessary additional costs?
Wow, good question. I'm going to talk a little, well, the special ed, I'm going to talk a little bit about it, but Jeremy now handles most of your special education here, so I'm going to answer just briefly, and I'm going to kind of let him, I think, deal with that a little bit. First of all, there's a lot of confusion about 504 and IDEA, and without getting into a lot of detail and giving you a legal brief on it, I think the simplest way to answer that question is that 504 is an anti-discrimination statute. Just like I can't discriminate against you because of your age, your religion, your sex, your race, I cannot discriminate against you in the educational environment because you have a disability. Okay? So think of an anti-discrimination. Now, IDEA is more of a remedial statute. What the IDEA says is that, look, this student has such a severe disability that they need more than just accommodations that someone might need with a disability. They need remedial action. They need affirmative action. They need something different. Like, we need to change the curriculum for this student to make them be able to learn. And so now our duty rises to a much higher level. 504, we just got to make sure if the student can't see well, we got to have them on the front of the room. If they can't hear well, maybe we have to have a microphone for the teacher. That's just accommodating, but we're not changing the curriculum. Under IDEA, we may have to change the curriculum for that student to learn. So they may have their own individualized education plan. We don't do an individualized plan for a 504 student. We do an accommodation plan, but not an individualized plan. Jeremy or Mike, either one of you talk about, maybe answer the issue related to avoiding disputes or how you help solve them and what you do.
Absolutely. This is actually a similar question came up a couple of years ago when we were interviewing with the board. The question was, well, how do we reduce costs? And I can tell you from my experience, there's been some pretty dramatic reductions in the past 2 years. Our answer then, I think, is the same as it would be now, which is education, and also taking the approach that several people, Bill's referenced many times tonight, of, we know what we do isn't arguing over widgets. It's arguing over the most important part of someone's life, their kid. And when you're talking about special ed, I think taking that approach is a way that it helps reduce tensions. It helps lead to, as Mike was saying, by and large, resolving complaints before they go to a hearing. I know I had a couple last summer for this district that were resolved before they went to hearing. And that's tremendously important if you're looking at controlling costs, because if you go to a hearing and win, forget about attorney fees, forget about the cost and the burden on your people. Just paying your hearing officer and your court reporter is going to be $10,000 or more. And so that's sort of a bar where in our minds, if we're looking to control costs, that's in our mind is, can we take care of this in a fair way, in a way that's respectful to the family, but is also respectful to your taxpayers by not unnecessarily going through with the hearing. So I think education, and your folks take great advantage of that, and they should with our webinars. I know I've called over your special ed people even to come to our office to view a webinar at our office that I was viewing. So I think education is a big piece, and then taking advantage of the retainer. And I know I get some really good, long retainer phone calls that you're not being charged for to go over some of that background.
Yeah, I think just to piggyback on that too, I talked about our administrator academy that we do once every year. We have 4 sessions. One of those is always, every year, dedicated to special education. And in fact, last year we did a whole 3 hours on how to avoid and solve special education disputes. So it was a whole 3 hours on how to help people solve disputes and special ed issues.
And I would just say, in special ed matters, that nobody wins when you go to due process. So we try to control costs by not going to due process, but we try not to go to due process because it's best for the school district and best for the parents. my goal has always been, and my focus has always been in dealing with special education matters, is let's figure out a way to resolve this. Because even if you go to due process, the times we've gone here at Northwest, we've prevailed. But you've got a parent who doesn't like it. And that, the whole idea behind the IDEA is collaboration between the parent and the school to develop a special education plan for their child. When you have a dispute that you can't resolve, that collaboration falls apart. So it's our goal always to maintain that collaboration, and we do that by trying to get it resolved without going to due process.
Anybody have any follow-up? Okay. We'll move on to the next question. Please describe your experience dealing with complaints from the Department of Education Office of Civil Rights.
Well, we know them all by first name basis up there. That starts. But we, sometimes I don't have always the nicest thing to say about that office, because sometimes I think they live in an ivory tower and they don't realize what we're really dealing with on a day-to-day basis in education. But we've been very successful in working with them. And in fact, they do know all of us by first name basis. We know them by a first name basis. And in fact, I can tell you that they've come to our presentations to learn. And in fact, we just recently did a presentation on, what was it? 504 in general, and we actually had somebody from their office come and want to be part of our panel. We asked her if they would be part of our panel to speak, and she said yes. And so we have a very close relationship with them, and we've always been able to resolve issues. And I think when we call them, we have an instant level of respect when the school district uses us, because they know that we know what we're doing. But we get into arguments with them and disputes, and sometimes I think they go a little bit over the top on things that they require, and we find a way to work it out. Any questions about that?
Okay. How will you help ensure that the school district remains justifiably acknowledged by the Ohio Department of Education and others as properly serving children with disabilities?
You say justifiably recognized, Mr. President. What do you mean by that?
Justifiably acknowledged by that the Ohio Department of Education recognizes us.
That's like being in compliance.
Being in compliance, or
good district,
no complaints.
Well, first of all, I don't think you can do this business, which is educating kids, without getting complaints sometimes. That just kind of runs with the nature, no matter how good you are. But I think I've talked very extensively about what we do to try to help ensure compliance. I mean, these seminars, these presentations, the webinars, the work that we do, coming out and we're meeting with your administrators and all those things. I'm safely say that you are compliant. My association with the Ohio Council of School Board Attorneys, Special Education Council, I'm at a seat, and I'm going next week. Like I said, every quarter, once a quarter, I sit down up at the OSBA office with a group of 7 attorneys, ODEs, Chief Legal Counsel, ODEs, Chief of Special Education, and ODEs, attorney from the Attorney General's office who does special education. And we talk about the issues that we're facing in school district. What's ODE thinks important? Where are they seeing problems? Just recently I had a school district, I can't tell you who, because I would divulge attorney-client secrets, but found out that they were committing a pretty major violation under a process violation. They weren't doing something right as they were filling out forms. What I did is I called the chief who's in charge of special education in the state of Ohio, Department of Education, said, this is Bill, got a problem, self-reported, said this is what we found out, we need to come talk to you about it. And within 2 weeks, she had a meeting with every person of any interest up there in the special education office. And we went up there, explained our situation, explained what we were going to do to fix it, requested and asked them to help monitor the situation. And they walked away very satisfied that we self-reported, we found it ourselves, and the plan that we developed for them was approved by ODE. So, a lot of it's just relationships and whether they respect you and they think they know what you're doing. I don't think if we didn't have that respect as a firm, if I didn't have that respect as a practitioner, I don't think I would have got that audience or that meeting. Any questions?
Our next question. Within the past year, our district has had high-profile incidents involving employee sexual contact with students. These incidents are destructive to our students, our district, our community at large, and damaging to the morale of our other employees. What proactive steps can we take to improve policy and abuse education among our employees and volunteers to assure that these incidents are minimized?
Well, I guess the first thing I would tell you is they're very unfortunate circumstances. And one of the things that I've struggled with as I've done this is it seems like those incidents are increasing in frequency. And I wonder if they're increasing in frequency or if they were always that way, it's just that now we know about it and we didn't know about it in the past. But it does seem like it's happening more often. I think that's a reasonable perception for someone to have. First and foremost, no matter what we do, sometimes you can't prevent intentional bad acts by people. You know, if someone wants to do something bad, you may not be able to prevent them from doing it, which is unfortunate, especially when you look at the fact that, you know, what I always try to focus on, I know everybody in my firm does, is the reason why we do what we do is for kids. And that sounds kind of corny, but that's a way that I've always been able to keep my eye on the ball and keep focused on when I'm having a bad day at work like everybody does. The best way I think you can do it, although it's not foolproof, is to have policies in place, to have education in place, to do things to try to help people understand that they are in an environment that may become tempting for them. So how do they avoid that? They are in an environment where if they begin to act inappropriately, they blur the line between student and teacher, they might find themselves somewhere down the road. I don't know how many teachers or staff members that get in that situation actually decided, you know, I think I'm going to decide to have an affair with a kid. I don't think they do that. I think somehow it gets there. So for instance, you know, we've talked to this, I've been out probably 4 or 5 times talking with administrators on how are we going to handle if we're going to allow students to get text messages from teachers? Are we going to have protocols in place? What about teachers being, you know, Facebook friends or social media friends? Do we have policies on those issues, and how do we address them? And what we've talked about here is, you know, look, it might be appropriate for a teacher that need to text a student, or appropriate for a coach to text a student. But how do we assure if that happens, that it's done in a way that's above board and everybody knows? And so one of the things the advice I've given to you all, and it's interesting because my son's school is doing the same thing now. Yeah, okay, we want to let coaches text the kids on the baseball team and tell them practice is canceled or if the field got moved. Guess what? You get permission from the parents for those kids to receive those texts, and every text that goes to the kid also goes to the parent, a parent. You know, so you have some of these policies in place because sometimes you can just help insulate those teachers from getting involved in those issues. And so the only thing that I can think that possibly is allowing this to happen more often now than in the past was because of the access that teachers can have to students now through technology they didn't have before. You know, the story I always tell is that in the past, if my coach wanted to talk to me, he called the house and he said, "Bill, I need to talk to you." Or he'd say, "Is your parent there? Is your mom there? Your dad there?" And I'd say, "Yeah, I had on the phone with my dad." My dad, he would say, "This is Coach Roach. I need to talk to Bill about something. Is that okay?" He'd say, "Yeah," and he'd hand the phone back to me, right? They don't have to do that anymore. Kids got their own phone. So I think the ability for access is different now, and that we have to understand that that's part of it. In fact, I've even asked OEA when they come and talk to teachers at the beginning of the year that they should spend 10 or 15 minutes on that. When their own union comes and talks to them and their colleagues talk to them about how to avoid those situations, don't put yourself in that position. But it's not foolproof, Mr. President. I mean, you do the best you can to avoid it, and you got to have education in place. And the other thing about that is you got to make sure that other teachers know that if they suspect something, they have an obligation to report. And that they can be just as guilty by not reporting if they believe that's happened. And unfortunately, I've been involved in too many of those cases that I wish I wasn't. And a lot of those times through investigation, we'll find out that there are other teachers in the building that had a suspicion and they didn't tell anybody. And to me, that's unacceptable. And so that's another part of the education. If I answered that okay or not, it's a big question. All your questions are an hour answer each, so I'm doing my best. So.
Any follow-up? Okay, we'll move on to the next question on a different topic. Does your firm currently have clients that are representing matters against the Northwest Local School District? Have you had any in the past 3 years?
I know we don't have anybody right now that we represent that's going up against Northwest, and I know we haven't had any in the past 3 years.
That's under the property revision. I should have started with, these questions have to do with border revision and financial.
Tax border revision, tax cases? No, I can tell you for sure we don't. We by nature would never take a case with a private corporation or a case with a citizen that was challenging their property value against the school district. It just isn't something we would do. It's similar to Mr. Fisher's comment. If somebody called us, we'd say we don't do that, but we can recommend people to you that do. I think as an attorney, I have an obligation to the public to make recommendations, but we wouldn't do that. You know, it's interesting. At Mr. Roberts Fisher, I think that's how I kind of cut my teeth on litigation. My first 2 or 3 years was spending 3 or 4 days a week in the board of revisions. And Bronson did the same, and we kind of always did. And then kind of realized that it was kind of an area that really required more than just sending a young associate to the case. And I'm talking, 15 years ago we did this. So probably for the last 7, 8, 9 years, it's been Gary Stradonsky in our office, who we're proud to say we made partner in January of this year. He's an excellent attorney. He's a great person on our team. He cannot be here tonight, but since Bronson has done it more closer to time than I've done, you can answer that
Well,
question.
sure, and as Bill said, we both kind of cut our teeth on this, and I myself have probably been through about over 1,000 Board of Revision hearings. I know Gary's probably been through more Board of Revision hearings than that. Both Gary and myself have been to the Board of Tax Appeals, several courts of appeals, Supreme Court. I think Gary's been at least once, I've been at least once. And we work really closely with the treasurers on those issues to make sure that if we are challenging complaints of evaluation, that they're the right ones to challenge. And if we are filing complaints for evaluation, that they're the right ones to file.
Do you have any other questions on Board of Revision at all, or? Yeah, but we don't have any clients right now. I can assure you that we don't.
Okay.
Yeah.
And just to be fair, you've got about 10 or 12 minutes left, and I've got
I
five
have a
more
follow-up.
questions.
I have a follow-up
Randy.
question. I'm just going to try to word this correctly. If a legal firm is representing us in Board of Revision matters, and they also have other attorneys with clients that they are representing against the district, is that a conflict of interest, or is that?
Well, I think that let me have 10 seconds at it, and then you have 10 seconds at it. There's two ways that I'm going to deal with this. One is it can be direct conflict of interest. If I represent you, someone in my firm's going against you, how do you know that we're not talking about your case over lunch? You know what I mean? We're not supposed to, but I'd be a little uncomfortable with it if I was a client. Yeah, right. Right, it's a direct conflict. But there's also, I think, some indirect conflicts. Maybe I sue a school district in Cleveland. But what if I make a law, because I have to advocate for my client against the school district in Cleveland. I have to advocate zealously under my bounds and obligations of the law. What if I get the Supreme Court to do something and I win that case, but it negatively affects you down here? That's not a direct conflict of an interest, but I think that's a problem. You see what I'm saying? So yeah, it's a direct conflict of interest, as Mike said, under our rules, ethical rules. I think it's greater than that. If I cross the line and start representing people against school districts, I'm good. I might do something and win. Bronson might do something and win. And then you're going to be like, well, what the heck, Dieters? You won that case in the Supreme Court, and now we're negatively affected. We just don't believe in that.
Next question. Do you have a full-time tax attorney or attorneys dedicated to the practice of municipal finance and specifically knowledgeable of sections 141 through 150 of the Internal Revenue Code, the accompanying Treasury regulations, relevant IRS revenue rulings, and private letter rulings relating to municipal finance?
I'll start, and then you got to save me. We don't do bond work, okay? It's way too specialized. It's just like we don't do intellectual property work. We don't do bond work. There are some things we don't do, and sometimes there are some things that our clients need. But we have well-established, long-standing relationships with firms in town that are high quality that do those things. So you guys have had bonds here since we've represented you. We've worked closely, I think, with Peck, Schaefer, and Williams in the past with you. We've kind of been a sister firm. They've now merged with Dinsmore and Scholl. But we know those attorneys, Brad Rui and Dolores, and all those people over there very well, and work very closely with them. We have tax attorneys that we use if we need to use that. We know a little bit about the tax issues related to payroll and issues with unemployment, but sometimes those are some things outside of our range, but we have experts to go to for that.
As I say, tax is a pretty broad area. If we're talking about taxes in the Board of Revision context, obviously Gary, myself, Bill, Jeremy, we've all can handle those issues. We're talking income tax things where we went to file, setting up 501c3s, everything like that. No, we don't do that. I learned a long time ago that it's better for my clients to find somebody who knows how to do it, make sure it's done right, as opposed to me trying to figure it out and cost you guys 10 times what it would cost you to make one phone call and get it right on the first time.
Okay. As a district, we depend on local property tax income and other sources to fund our operations. As our attorney, you may be called upon to examine the valuation claims of property owners and represent us as we challenge those claims. Please describe your experience with the County Board of Revisions the Board of Tax Appeals, and the Common Pleas Court. Further, explain any additional experience you may have with this topic.
Well, I think as I said, alluded to earlier, myself, I know for a fact I've got over 1,000 board revision hearings. I know for a fact Gary's got probably double that. Both of us have been in front of several courts of appeals, Common Pleas Courts, Supreme Court, Board of Tax Appeals. So I would suggest to you our experience is vast in that area. We've been very successful in what we've done. As far as our approach to it, we work, use Randy's example, you'll get complaints that get filed by March 31st every year. Those complaints come in, we work closely with them to say, hey, this is asking for $1 million reduction. This is something we want to challenge, this is something we not want to challenge. We also do a review of the sales for the particular year to see if these sales, if someone has willingly paid more money for a piece of property than it's on the tax books for, is this something that we think that needs to be brought up to accurately reflect the value so that particular taxpayer is paying their fair share in relation to everybody else. And we don't do things without talking to the treasurer. We don't, it's not our job to do that. Our job is to make sure that we work together, making the right decisions for the district, and ensuring that if we are challenging an evaluation, it's one that should be challenged. If we are filing for evaluation change, it's one that should be filed.
And typically, at least when I did it in the past, we usually didn't file against residential owners. And if we had inside knowledge or additional evidence, not inside knowledge, but additional evidence that we knew that a property was distressed, or there was a problem, or there was something, we typically would talk in counsel not to file in those types of cases.
The difficulty you have is on these filings, we don't know why they're asking for it when they file. We don't get the appraisals and everything else to show up to the board of revision hearing. So it's a little bit of a guessing game. You basically base it on the numbers.
Any follow-up? Next question. Assuring that all property owners pay their fair share of taxes to the school district is an important objective of the board. Tell us how our board should craft a policy that will properly guide our legal counsel as to how this objective should be reached. What input would you want from our board in developing this objective?
Okay. The danger of a policy, you can certainly have a policy, and the policy would be very simple. It would say, we are not going to challenge valuations unless they are in excess of X, whatever that number would be. And we're not going to file for challenging valuations unless it is in excess of Y. You pick the number. That would be what your policy says. The difficulty in that is that policy is a public record. There's a lot of smart attorneys out there that file board of revision complaints, and they know the board of education Northwest says we're not going to challenge anything above, below $200,000. I'm going to make darn sure, if I can do it, that my complaint is going to fall directly under that threshold, so that you're not going to come. The problem with having a policy like that is if you have the policy, you shouldn't violate it. So now you're stuck. So that's the danger of having a policy. But having said that, we have drafted policies for clients in the past. They've never been implemented, but they're very general in nature. There's been some specificity in one or two, but they weren't adopted. But I guess as far as information, we want to know what your comfort level is. Where do we think, and then we'll be talking to Randy, where do we think the drop dead zone is as far as when we would challenge either going up or going down? Any follow-up from that?
Next question. What options are available to the board about making records available that are not covered appropriately under the open meetings law or the public meetings law?
So you're talking about, I'm not sure I understand.
Well, there's a lot of records that exist that is there any way we could make them more available? Now, I realize we couldn't make personal student records available, but there's financial records, and is there a way to do that?
Yeah, I'm probably almost out of time. I don't know how many questions you have left, so I'll try to be brief. But good. Okay.
If for the favor of the board, if you keep the answer under a minute, let's just get the last three asked. Is that okay?
First of all, we have extensive experience in open meetings, sunshine law issues. I've taken a case to the Supreme Court, which is the Talawanda versus Central case. I've had numerous cases in the Court of Appeals. All of us are well versed on all those issues. So again, you won't find a firm that has more experience in dealing with those issues than us. Public records law is simple. There's things that are records. If those are records and they're not, and they're a record because they document the organization's functions, policies, and decisions, they're subject to being open. So there are certain things that you have an obligation to provide for this record material, and it's not exempted under any other issue. So you really can't create a public record. If it's a record and it's public and it's not exempt under some exemption, it has to be given over if there's been given access to. As you indicated, there are certain things like student records you can't turn over. There are things like attorney-client privilege information that you shouldn't turn over. But that attorney-client privilege is a privilege that you hold as a board. You can waive it. The board could waive it. So there are things you could turn over that you're not required to. There are things that you're not permitted to: medical records, social security numbers, addresses, student information, direct person identifiable information. But as far as what you want to report as a board or what you want to give people access to, you have a lot of flexibility to do that. And there really is no ability to create a record. It either is a record or it isn't a record. And it's a record if it documents the organization's functions, policies, and decisions. The next question is, well, if it's a record, is it a public record? Well, student records document those things, but they're not public because they're exempted. It doesn't have one of those exemptions, it's public. We got to turn it over if it's asked for.
Just go right to the next question. How many school districts do you currently represent?
I have a list in the pack of our districts that we represent. It's on the right-hand side. I think the last check was around 130. Now, it sounds like a lot for 8 people. I will tell you that we have probably about 2 dozen that we work with a lot. We have some districts that I might only see once every 3 years. They call me up and drive up to the Michigan border in Ohio, negotiate a collective bargaining agreement, get in the car and give them a salute and say, see you again in 3 years. And I may not even hear from them in 3 years. I just finished a contract up in Bryan, Ohio, for a client, and the last time I talked to him was 3 years ago. But we have about 130 clients, and they range from the Michigan border over to the West Virginia border, but most of them are concentrated in, obviously, our 4 or 5 county area down here. And I got a list here in the back if you want to look at them.
Okay. Last question had to do with hidden costs with fees.
Hidden costs
When
with fees.
we see your fees, what are the other costs that aren't in the fees that are?
Well, first of all, we only travel. If we do charge you for travel, we only charge you half time. Some firms charge you the full boat on travel. We only charge half, okay, which we think is giving you a break. Hidden fees, I don't think there are hidden fees, Mr. President. We don't hide anything. We're very transparent. I put the level of specificity of our bills up against anyone. In fact, I've had clients call me sometimes and say, you're too damn specific in your bill. Cut it out a little bit. I don't want, but we're very transparent in it. Yeah, I don't know if, we do bill for reimbursable expenses. I mean, if I have to drive to Columbus and pay $15 to park in a parking garage because I'm at court up there, I'm going to charge you an expense for that. I'm going to charge you mileage. If I have a filing fee because I have to file something in court, I'm going to charge you the reimbursable. But there's no hidden fees. We don't hide anything, like I said. The fact that we give a great value. You're not going to. The hidden fees are when 2 attorneys show up to do the work of one. The hidden fees are when a letter should be written in 20 minutes because the attorney knows what they're doing, but instead they research it for 3 hours. Those are hidden fees. We don't do that. We're too busy to do that. To be honest with you, we are. We're too busy to do that.
Okay, yeah, we've asked everybody the same questions.
Yeah. Okay.
And that was all the questions, and you're within a minute of when you should be. So.
Okay, just real quickly then, if I have a minute, I want to kind of go through. I have the packet here I wanted to give you to tell you what's in it. The first thing is that June 17th, we dated it, but it's basically the letter that went to Mr. Bowling when the request went out. You'll find every one of our resumes behind there. I think you're going to see a wide range of experience. Both myself and Mr. McCord also have experience in the military, but you're going to see people from all different parts of the state of Ohio, all different colleges, all different law schools, so it's a wide variety. Have our brochure here. I think also down in there somewhere there's a flash drive that has some of our blogs on it. It has some of our newsletters on it. I think Pam, she's great, isn't she? Got you a pen, too. It's a really nice pen, believe it or not, for a free one. And we have a copy of our school law review. I also want to point out, if any of you are interested, there's a school law seminar given by the Ohio State Bar Association this year. I'm speaking at it, but I'm more proud of the fact that Pam Lice, one of our associates in our office, actually was the course planner. She was asked by the Bar Association to plan the entire course, and it's in Columbus in August. And I think there's also the list of clients, so that's what you got in your little goodie packet. So, any other questions? But
this is the same that we got.
I think so, yeah. Okay. I just wasn't sure if you got it.
All right, thank you.
Okay,
I really appreciate your time and coming out this evening, and thanks for a great presentation.
Okay, thank you.
Thank you.
Thank you.
And if the board wishes, we'll take we'll come back at 8:35. I'd like to call this meeting of the Northwest Local School District Board of Education back to order. I see that everyone's here, so we'll go ahead and proceed with the next attorney interview. The firm Brickler and Bricker and Eckler. And welcome. We're glad you're here. What we've done for a rule is you have 1 hour to present. You can talk about whatever you want to talk about. We do have 16 questions to ask you, so please try to allow time to answer those questions. Some of them are a little complicated. So, and there's a microphone there. If you just make sure that the red light is on, we'll be in fine shape.
Well, thanks for having me. Do I need to do anything?
Jim, there should be a red light on
So I
there.
touched it.
Yeah. Red light's on.
Yeah. Well, thank you all for having me. As some of you know me, for those of you that don't, my name is David Lampy. I'm with the law firm of Bricker and Eckler. The reason some of you know me is that this was one of my first school districts back when I was a much younger attorney, in which I handled a lot of your day-to-day legal representation back in the mid-2000s. I feel like I've developed some good relationships with this school district. This district's near and dear to me for a variety of reasons, for the work that we've done together. I grew up in Green Township, so this is one of the districts that encompasses where I was born and raised. My grandparents grew up on Jessup Road, lived there for 45 years. They're buried in St. James Cemetery, so I know the area well. I know the demographics of the students you serve. I know your administrators. I know several of the board members here today. The reason we would like to bend your ear today is to talk about what we can do as a law firm. I believe, based upon the firms that you're interviewing today, we are best suited to serve the needs of this district. Looking at your demographics, looking at the size of this district, looking at the financial needs of this district, it's a district that I believe needs legal services that you may not necessarily find in a smaller firm or possibly in kind of general practitioners. You're going to hear a little bit as we move forward as to the strengths of our firm. And our firm is based upon, in large part, two types of markets. Number one of our practice areas is serving healthcare. We're one of the strongest in the state. The second main focus of our firm is we represent public bodies, and specifically public school districts. We have 19 full-time attorneys in our education practice group, by far the largest in the state of Ohio. You're going to hear a little bit not only about the component parts of our education practice group, but also of some of the other practice areas that help support our work. Based upon the fact that we have the size to specialize, we have certain individuals that have been developed specific niche expertise in the area of education law. You're going to hear from Laura Anthony here in a little bit. Laura's practice is devoted specifically on student services and special education. She trains administrators across the state of Ohio. In fact, she's flown in to various states across the country to speak to administrators on special education because she is one of the premier minds in that field. Kimball Carey, he wrote the book on school law. And when I say that, I'm not joking. Every district administrator in this state, for the most part, has the Ohio School Law Manual. This man wrote that book. Our firm works on it every year. We track legislation. We track changes in the law. We update our administrators. And frankly, when you look at our collective expertise, it's not comparable with the firms that you're interviewing with today. And I'm not saying that necessarily as to be on the offensive. It's just a simple fact. We have literally hundreds of years of collective school law experience that we believe we can bring to the table. And if in fact the board is looking to make a change in law firms, I would ask that the board make a smart change here to actually improve legal services, to bring in folks who actually know and work on specific areas of the law, to not only give you more efficient services, to give you more responsive services, but frankly to give you the best possible services in the state. With that, I'm going to have Laura Anthony explain to you a little bit about our education practice group. Laura is also the chair of our firm's education practice group, so she has a better handle on kind of the day-to-day things that some of our folks do. Go ahead, Laura.
Thank you. Thank you again for having the opportunity to come and talk to you guys. I am the chair of the Education Practice Group, which puts me in a unique position. As David said, we have 19 full-time school lawyers. But in addition to our 19 full-time school lawyers, we have different practice groups that are dedicated to serving the needs of the education field. We have construction lawyers that help schools with their issues related to facilities. We have our public finance lawyers that deal with anything related to their fiscal needs. And so in addition to the 19 full-time attorneys that serve school districts, the other attorneys in our firm, it's a large firm, but they know how to serve public entities, and they know specifically how to serve school districts. In addition to just talking about bodies, our team is more experienced and has a broader scope of expertise than any of our competitors. And as David said, we have 19 attorneys, but our clients have access not just to 19 bodies. A district the size like of this district should expect its legal team to be responsive, accessible, to provide same-day service, and you need a team to be able to do that. When David's out at collective bargaining, if I'm at an IEP team meeting and a district needs an answer to a question, having a size of that kind of team to be able to provide backup helps our clients have immediate access to legal services. So let's talk about experience. 18 of the 19 of our school lawyers have at least 10 years of experience in the education field, many serving as educators, social workers, Department of Education consultants, and in other fields prior to joining our team. And over 50% of our lawyers on our school law team have at least 20 years of experience. So you know that when you call us, you're not just dealing with a new lawyer who's basically training on the job on your dime. This brings value to our clients. And one of the ways that we bring value to school districts is our ability to quickly provide legal advice. For most things, you don't have to call us and have somebody research an issue. With the hundreds of years of experience, we've been there, we've done that. We've worked with districts this size, we've worked with districts within this demographic, and if we're able to answer a question in a 10-minute phone call versus another firm who might not have that type of experience, excuse me, that brings value. And so when you're comparing firms with different hourly rates, if it takes us 10 minutes to do something and it takes somebody else 2 hours, you can't compare hourly rates, because if we can do it faster, we can do it at greater value. Let's see what others I wanted to cover. You had mentioned a couple of things, David. I wanted to piggyback on some of those. The integrated team approach. When I talked about other fields, other lawyers in our team, in addition to public finance and construction, there may be things that this district could take advantage of, and it's expertise that we have in-house. Intellectual property. We have lawyers who deal with intellectual property all the time, not only to Fortune 500 companies, not only to big universities, but to school districts when they have to deal with those issues. And I'll give you an example of that. I was working with a school district right here in Southwest Ohio, and they had an issue about their special ed software. They wanted to get rid of the software program that they had purchased because they're teachers, they're intervention specialists, and frankly, everybody who was associated with the special ed program couldn't stand it. And it was creating discord, and it created personnel issues. And so the district shopped around, but had a very unfortunate contract. Well, this software company coming here from the West Coast, we had a dispute about getting out of that contract. Well, this became a special ed record issue. It was a student special ed compliance issue, but it morphed into an issue regarding contract interpretation, labor, and intellectual property and copyright issues. And so when we're there at the table with the software company trying to get out of the contract, who do we have? Well, part of our team in our intellectual property group includes somebody who's not only an engineer, but a software designer. That was his job before he went to law school. And so we were able to have at the table somebody who knows intellectual property law, who also knows how to develop software. That kind of expertise you're not going to find in a small firm. And because we have a large firm, multiple offices, and multiple people who can bring expertise, that brings value to school districts. That's the kind of services that we're providing to our corporate clients, and it's the service that we're providing at a discount rate to our education clients. We devote an incredible amount of time and talent to professional development, and that's one of the ways that we serve public schools, and it's the dedication to the education community. We don't have lawyers on our team who sue school districts. We don't. We have dedicated our practice to the defense and management of school districts. And so Our dedication to that industry is also demonstrated by the amount of professional development, most of which it's donated time. So when Kimball writes the book, I do speaking engagements, the Ohio Department of Education calls me to do training, that's donated time. And so that's part of our commitment to the public sector. And on a more personal note, David mentioned, and, thank you for tooting my horn, but on a more personal note, I would add that having a special ed team that's highly regarded by the leadership of the Ohio Department of Education and the folks that do compliance and monitoring in the Ohio Department of Education, that also brings value to school districts. Unlike our competitors, we have 5 attorneys who devote a significant portion of their practice to special ed. Again, when I'm at an IEP team meeting, who's there to answer the phone when another district has a call? Now, when I say we're highly regarded, why do I think that? Well, I'm drawing this conclusion because our lawyers are routinely asked to collaborate with ODE on things like training. I'm on the panel for the statewide leadership conference. I think I'm the only school district lawyer who's on that panel. We're asked to collaborate on the selection and training of hearing officers and mediators. We're asked to collaborate on rule development. So I think these opportunities that we were given suggest that we're highly regarded by the Department of Education, but call them yourself and ask them, who should you have assisting your district in those needs? So I'll turn it over to David or Kimball.
I want to give, just to kind of piggyback on that, there have been some specific cases that I've encountered in the past couple of years. I'll just use those. It's been longer than that, that frankly I wouldn't have been able to handle without a team behind me. And I feel that our firm was uniquely suited to handle those issues, and I'm not certain that you're going to find that type of quality and collaborative approach elsewhere. First example, we've been retained by a school district in Butler County to actually pursue litigation against an independent auditor that performed auditing services for the Treasurer's Department, and actually to pursue litigation against their former treasurer. It was a very complicated set of circumstances in regards to certain expenditures that we believe were illegal. Some of you know that I cut my teeth as a litigator. The more and more I delve into school law issues, I'm not in the courtroom as much as I used to be, but I understand school finance, I understand board business, but I don't have as sharp of a handle on, frankly, in this particular case, auditor malpractice. That's something that is more in the line of a business litigator. At my firm, I'm able to pull in resources to bring in a litigator to assist me. He knows accounting malpractice. He knows the type of issues that need to be proven in court. I understand the school law aspect of it, so we're able to team and do a collaborative approach to make certain that that particular school district is getting the best possible resources they can get. The other thing that I believe we have a unique resource in is that we have a team of folks who understand finance back and forth. And we were able to use those individuals at the time this all hit for this particular school district. When the auditor of state found out about the issues, one of the demands they made was that the amounts that were an issue be paid back immediately, which would have been absolutely crippling for this particular school district. Using the resources we had in our firm, the firm understanding of public finance law, and frankly the contacts that we had in the state auditor's office, we were able to work out a plan whereby the district could rectify the situation without frankly crippling the district, and it saved literally hundreds of jobs that would have otherwise been riffed had the district had to reduce its budget in order to make up that kind of money. And I don't think this district would have got those services anywhere else in this state other than our firm. Another example that we're currently working on, we've been brought into another local district to deal with bullying and discrimination claims. It's become a problem, frankly, in a lot of districts around this state. Ever since the legislation whereby the board needs to adopt their anti-bullying policies, it is becoming a more and more frequent complaint levied by students. So we've been come in we've been retained to come in to identify the problem. One of my fortes is conducting misconduct investigations. That's what I do. I don't understand special education law and some of the other issues as well as I should, so I rely upon individuals like Laura to let me know, okay, if we need to put in certain type of safeguards or certain type of remedies for these students to protect them, and let's say some of those students who are engaging in the misconduct are under an IEP, are under a 504 plan, what can I do and what can I do? She's been a valuable resource in guiding the district through these types of things. The other issue that comes up a lot in these types of situations is the whole issue of race as it pertains to student discipline. As some of you know, there's been some regulations passed down by the U.S. Department of Education governing how you can discipline students of color. We have folks who've tracked that legislation. We understand what we can and can't do. So when it comes to making decisions on the discipline of students of color, we have the team of people that not only know the legislation but also understand how to do the investigations in these types of situations. So I think we're well served in handling situations. I know you have a diverse student population. I know you have about 15% of your students on IEPs or some form of disability. I know your segment of your population is about 50% economically disadvantaged. Those are all factors that have some very real regulations and statutes that come into place that you better make certain you have a team of lawyers that understand those types of regulations as you move forward in tackling those types of situations. I know we have a couple questions. I'll give you one or two more examples. One of my other local school districts had a dispute recently over the installation of defective chillers. They called me, I'm their point person, and said, look, we had these installed within the past year. We believe we're still under warranty. The contractor is telling us that this is some type of maintenance problem that they're blaming on our maintenance staff, and they're refusing to replace these chillers. We need some help. So I bring in one of our dedicated construction folks, and just by way of reference, our construction lawyers only represent the owners, which means they only represent the public schools. They don't do work for the particular subcontractors. They don't take sides against school districts. Again, we align our firm to completely support every aspect of public school districts. So the particular individual that installed these chillers knew our firm. And within a half hour of a phone call to get up to speed on the situation with their director of business services, and a simple letter off to the manufacturer of these chillers, they replaced the chiller in full with one letter, which I guarantee you, if that particular contractor didn't know the firm they were dealing with, this would be in litigation right now, which would have cost this particular district a lot more money. And then finally, we've been involved recently in situations. We were one of the first school districts to be drawn into some of the data manipulation cases that I'm sure many of you have heard about across the state of Ohio. We happen to take lead in the investigation and frankly the personnel action against the individuals involved in a local school district in the area. I brought in a person to help assist in understanding EMIS, in working with the Ohio Department of Education on how the particular rules are interpreted by ODE. As I said, my background is misconduct investigations. I took lead in doing the misconduct investigation, was supported by folks from our firm who understand EMIS, who have contacts with ODE, and frankly, some of the various law firms that are now representing other school districts in the state have been calling us to kind of get a roadmap on how those types of investigations are handled. So in short, and I want to leave time for some questions, I think you'd be in great hands to use our firm. There's obviously a desire by this board to make a change. Make the smart change. Put your district in the hands of a firm that has the capacity to do the work. You're not going to get any firm that has better expertise than us. And if you've noticed, our rates are very comparable to the firm you're currently using. when you add the fact that we have literally hundreds of years of expertise behind us, including archive materials that I draw on all the time, you're going to get more efficient services and you're going to get better services. So with that, I'll leave time for answering some questions.
All right, we have 16 prepared questions, and whoever wants to answer them, please come to the microphone. The first would be in the human resources area. Explain the differences between the current law for OTES, OPES, and the recent changes to that legislation.
Why are you two looking at me? You know not to look at me, so. Oh, I'll stand up. Kimball may be the person. Kimball is general counsel for BASA, so you educate administrators on this. I try to, and I'll just, while I'm standing here, thank you for having me. I didn't have any scripted remarks. I tend to generally just go on pure charisma, so that's sorry. Yeah, OTES and the change in teacher evaluation. Wow, that's really right on the edge of, I think, the things that school administrators in particular are struggling with right now. House Bill 153 really, to me, was a new paradigm was created. I don't know, we quit using the word paradigm and maybe I should let it die. But I think when they did that, they were really taking evaluation away from the bargaining table in a very, very big way. House Bill 153 said, we're going to create a state framework for education now, okay? And it's going to be a real accountability based, it's going to, growth is going to, in every district in the state, a teacher's performance is going to be measured in large part by student growth. And we're going to have a state framework for teacher evaluation. A very significant development. Up until this time, we've had 613 districts designing how they want to evaluate their teachers. And we think of that as local control, and there's a lot of good about that. But for better or worse, the legislature has said we're going to have a state framework. It's going to have these pieces. And the way that they said it is, we're going to have a state framework, and evaluation going forward is going to be based on a board policy. And look at that word policy, which conforms to our state framework. Each board is required to consult, and the word is consult, with teachers concerning the policy. So, you have the legislature taking evaluation and saying it's going to be this, there's going to be a state framework, and each board individually can design something as long as it conforms to the state framework. But it's going to be controlled by your policy as a board policy as opposed to the collective bargaining agreement. Well, and this, I don't mean this to be an anti-union rant here at all. It's not. It's just what they did. And I'll just say the teacher unions have just not taken very well to this concept, and it's really not sinking in. One thing they had to come along the following year and say is, and also, having created this new structure, we are going to say you cannot collectively bargain this. They didn't say that the first time, but they did within the next year. They had said that. This cannot be bargained. I'm just telling you, this is not going down well with out there in the trenches. David's a guy going out, trying to bargain. They're just not buying it. They are bargaining. They are proposing many things in evaluation that are not in the state framework. And that's the difference. We have all these, the difference, and I think that was your question, is from the status quo is we have 612 evaluation procedures out there by and large in negotiated agreements. And now we're trying to transition. As of July 1, 2013, it was supposed to be there. We are going to have a state-designed teacher evaluation system. The struggle is over who controls that and can you bargain it, and that's what's going on right now. And I hope that answered your question.
Okay. The way we are set up here so that you're in control of your time is if you want to, you can ask any of us if we have any follow-up questions. So if you want to say, do you have any follow-up questions?
Well, are there any to that? I've kind of held forth on it. It's I guess you can tell it's been in the front of my mind lately. I've been working with a couple of boards. I'm not a true at-the-table bargainer like Dave is, but working with a couple of boards really struggling with this. One of them, I'll just tell you, is a career center board in a rural part of the state. Pretty strong relations with the teachers. And we're able to make this conversion to a policy-based evaluation system. Another district, probably more typical, local district, well-established teachers bargaining unit, a lot of stuff in their agreement on evaluation. Boy, I tell you, it's not going well. They just, and the sad part about it is we seem to be generating bad will over it, which is not intended at all. It's just, this is what the legislature has done.
One of the things, if I can follow up, Kimball in our firm prepare what are called Bricker bullets. They are regular legal memorandums that analyze changes in the law. And we send them out to our school district clients, and I'm sure Andrew and some of the folks here get them as well. One of the things that Kimball recently sent out was kind of a follow-up on the whole OTES framework, kind of very similar to what he just addressed with you, basically saying, look, folks, let's remember what this is all about. This was promulgated by the General Assembly. They had a state framework in mind. They want the board policy to follow state framework, and there's specific language in the statute that says these things are not subject to collective bargaining, because we were seeing school districts start to deviate and head down paths led by unions that they necessarily didn't have to go and frankly shouldn't go. And so we within the past couple months sent a reminder, just basically reminding folks, this is what the General Assembly intended on this. Kind of a gentle reminder, stick to your guns sometimes.
Okay, we'll go on with the next question. Have you reviewed our Northwest Local School District labor contracts? What are your comments about the contract provisions?
I haven't. Yeah, we haven't. It's been a couple years since I've reviewed your labor contract provisions. I mean, I know very well that you have labor contracts with your teachers and your classified folks, but to tell you the truth, we have not reviewed the specific contract that's in place right now.
Any follow-up questions?
No.
Okay. What is your approach to labor negotiations? How will you help to advocate on behalf of our board?
Okay, that's a good question. The way I normally handle labor negotiations is I believe I'm successful when I outwork my opponent. And that means getting with my people, identifying my board negotiation team, and getting with them early. I normally will review every collective bargaining agreement that I handle well in advance. And I put a spin on it in such a manner that if I was running this school district, how would I like that bargaining agreement to read? What are the changes in law that need to be made? What are things that possibly the administration hasn't thought about that could potentially improve the collective bargaining agreement in favor of the board? And I'll put together normally a red line version of that contract with analysis and comments, and I'll get that out to our bargaining team months in advance of when we actually would commence negotiations. that proves to be a very valuable tool for the board's bargaining team to start reviewing what needs to be done to update the contract, to get it in compliance with the law, and possibly to again remind them of things that potentially they could pursue to improve the contract on behalf of the board. I'll want to have a meeting with your insurance consultant to see where we're at as far as health insurance, dental insurance, any of your insurance policies. Compare them with where you stand with your peers. Determine if whether or not your provisions are where you should be for the particular financial state of your district. I want recommendations from the insurance consultant to help guide our decision-making process. Preferably, I would like, in fact, even for one or two members of the union to sit in on a briefing by the insurance consultant, because in my opinion, a lot of times they give very clear and in a lot of instances valuable advice for both sides, so they understand what needs to be changed, what's potentially coming down the pipe that needs to be fixed sooner rather than later. Once that's done, the next thing that has to be done, I need to get clear directives from the board. I'm negotiating for all 5 of you, and I need to know, I will not leave a board planning meeting and head into negotiations until I know exactly what my marching orders are. And if there's any doubt, and frankly, I have many boards that their board members have differences of opinion on how they want to go in negotiations, and I will not leave until I have a majority of people telling me exactly what my goals are going into negotiations. And I have boards that are very aggressive and want me to be very aggressive. I have boards that are less aggressive, and it all depends upon the particular board, because you guys are my client. I'm going to serve the will of my client, but I need to know exactly what I'm doing. And you would be surprised how often you get into a situation in which you sit in a board meeting and you work and work and work, and I would say sometimes the hardest negotiations is actually with the board to make certain that we are all on the same page, we're united on what we're going to do, and I have clear marching orders. Once I go into negotiations, what I will do, given my background as a litigator, I treat the negotiations like a trial. I am not a screamer. I am not a threatener unless I have to be. I will analyze the union's proposals through similar cross-examine techniques. I've had, as recently as 2 days ago, a building principal tell me, you know, your style is different from the attorney that used to represent us. He would just yell and say no and leave it at that, and we'd get nowhere. You're able to do that by leading the union members down a series of questions. I already know the answers to the questions. I lead them down into a situation in which inevitably gets to the result that we need to get to either get the board's proposals into the contract or potentially to drop proposals led by the union that A, either don't make sense, or B, aren't in the best interest of the school district. So I try to treat it as a business transaction, which frankly it is. I think the more you bargain with emotion, the more that leads into the union's position, because the union bargains out of emotion. And a lot of times they will bring proposals to the table that are led by emotion that maybe aren't in the best interest of the school district. So that's kind of it in a nutshell.
Next question to dovetail off that. Discuss your experience negotiating collective bargaining agreements with a teachers association represented by the Ohio Education Association or a bus driver association represented by the Ohio Association of Public School Employees.
I bargain for small, medium, and large school districts across the state of Ohio. I have school districts I bargain for here in Hamilton County, in Butler County, in the Dayton region, Warren County, and up into Columbus. So I've bargained with many teachers unions. Obviously, almost every school district I just referenced has a teachers union. Most of them have either bus drivers or just general classified unions. So I have several school districts, at least from a population standpoint and a budgetary standpoint, are very similar to this school district.
Moving on to the next category, student services, special education. Explain the difference. Explain the. So do you want me to read the question?
Oh, no. I can already tell you.
You already hit the bell, so you
yes,
just have to go ahead and answer the question. Explain the difference between school law and civil criminal law as it pertains to student disciplinary hearings.
Okay, well, I actually served in the distinct pleasure of serving as several school districts hire me to be the student discipline hearing officer, both as a board designee and sometimes as other designated hearing officer positions. So I can tell you that from the perspective of a board designee, there's a distinct difference. However, there's a lot of times when people who are hired by families, they're criminal defense lawyers, they don't see that distinction as clearly as I do. School officials, when dealing with student conduct, have pretty broad discretion in determining what conduct violates the appropriate standards in the school and to issue appropriate discipline. And they are not held to the same standards as law enforcement officials when they might be regulating similar conduct out in the street. So for purposes of search and seizure, there's a different standard in the schools as there, in the different standard in the criminal context. For purposes of witnesses coming in, for purposes of saying, using Miranda rights or detaining or interviewing students, there's different standards. And for making a determination as to whether or not a student violated the code of conduct, that standard for school officials, be it the principal, any other administrator who's dealing with student discipline, they're going to have a lower standard. They're going to have a standard of, is there a preponderance of the evidence? Do I think more than 50% that this child violated the code of conduct? Versus something maybe in a criminal court that would have a higher standard. If they want to search a student's locker, for example, lockers under your district policy likely are the property of the school district and can be searched at any time with or without reasonable suspicion. And that's not the standard out in the community for law enforcement officials. Similarly with other searches of students. If you reasonably suspect that a student has a weapon on them, you don't need a warrant. You can have reasonable suspicion. You can institute a search when there is sufficient basis to think that that search will result in finding a weapon, finding drugs, things like that. So there's a lot of different standards in those contexts. Any follow-up questions to that?
Next question. Explain the relationship between IDEA services and 504. Define each term and the characteristics required for qualification under each category.
Okay. Do you want me to define the characteristics?
Well, I'll go ahead and read the rest of the question.
Okay, I was going to take notes because there's a lot of parts to your question.
Okay. Explain the relationship between IDEA services and 504. Define each term and the characteristics required for qualification under each category. If special education disputes do arise, how will you help to amicably resolve the disputes and help avoid unnecessary additional cost?
Okay. All right, let's take the first part of your question. Define the relationship between IDEA and 504 and define each term. The relationship between IDEA and 504 are that they're very separate laws. They're distinct laws. People often confuse those laws, but they're federal statutes that govern, in part, the education of students with disabilities. IDEA stands for the Individuals with Disabilities Education Act, and in fact, as a couple years ago, was now defined as the Individuals with Disabilities Education Improvement Act. And under the current reauthorization of the IDEA, an eligible student, you said to define who's eligible. An eligible student would be a student who has a disabling condition that adversely affects their education, and for that reason, they require special education or related services. There's 3 standards for eligibility under IDEA. And those are your kids who, if they're eligible, they're going to get special education under an IEP. That's a very prescriptive federal statute, which our Ohio operating standards are modeled after, but it's very different than Section 504. Section 504, for many schools, is perceived as kind of the miscongeniality in the beauty contest of special ed, and it's not. It's not the second place finish. If you don't meet IDEA eligibility standards, then you move to 504. Instead, 504 is an anti-discrimination statute. It's administered by the U.S. Department of Education's Office for Civil Rights, and complaints go to the U.S. Department of Education's Office for Civil Rights for violations of those rules. And for students to be eligible under Section 504, it's a much broader eligibility. And when the ADA, which is the Americans with Disabilities Act, was reauthorized, had some amendments in 2008, that eligibility for schools expanded tremendously. So not only do you have students who may be eligible under 504 that you think about that may be special ed like, but you also have students who have health issues, like diabetic students, or students with significant allergies, your kids who have life-threatening peanut allergies, or asthmatics, or things like that. Those are all students who are protected under the disability protections of Section 504. The eligibility standard under Section 504 is that a student has to have a disability condition that results in a significant impairment of a major life activity. And that major life activity could be learning and concentrating and thinking, all the things you think about, reading in schools. But it also could be breathing, if that's your asthma kid. It could also be their circulation system. That could be the kid with a heart condition. Those kids are also protected under 504. And that's why I like to say they're very different standards, because under IDEA you get special education. You can also get special education under 504, but you also get protections for things like non-discrimination. So if I'm a special education student, or let's say I'm a student with diabetes, and I'm harassed because I'm going down to the nurse's office to get my insulin injection, Section 504 will protect you from harassment. And individuals can file complaints with the Department of Education's Office for Civil Rights. Which leads me to the next part of your question, which was about disputes. I am not a litigator, although I do special ed litigation. So unlike David, when I'm dealing with a special education dispute, I recognize the context. Everybody in the room probably has a kid. How hard would you fight for your child? That's what a special ed dispute is about. It's about a parent sitting there across the table thinking, I need this for my child. My child is disabled. So going into a special ed dispute with a no holds barred, take it or leave it, this is my way or the highway, is not the way to go. And it doesn't result in favorable decisions for school districts or cheap way of getting out of disputes. It actually creates a lot more time and expense. So I go to IEP team meetings and I try to resolve concerns when there's no litigation. I go to mediations. I try to bring all the parties together because at the end of the day it's about a kid and it's about a child with a disability. If I have to, I do litigate and have done so many times for districts around the state. But I also represent districts in complaints to the Department of Education, both the U.S. Department of Education's Office for Civil Rights and the Ohio Department of Education. And I feel like in the special ed context, it's kind of like if anybody's been through domestic relations dispute, you don't get to walk away in special ed. You got two litigants. It's the parent and it's the school district. And guess what? They're intertwined until that child graduates or the family moves out. So I know that in conflicts regarding special needs students, you have to take a different approach. Follow-up questions?
I hope I can interpret this correctly. Let me go ahead. Have you ever been hired by a parent to go against another district to help?
I have been asked.
To help their child get the benefits that that parent thinks they deserve?
I have been asked on almost monthly basis to be hired by parents, and I do not do that.
Okay.
My practice is exclusively representing schools.
Okay. Thank you. Next question. Please describe your experience dealing with complaints from the Department of Education Office of Civil Rights.
It is a wide variety of experience. So the U.S. Department of Education's Office for Civil Rights enforces many different statutes. Section 504 is one of them, and I just described the complaint procedures there. But they also investigate claims of disparate discrimination, disparate treatment and discipline. For example, I just assisted a district in a very long and ongoing class complaint where families alleged that the district was discriminating against African American students disproportionately through disproportionate discipline practices. And so they filed a complaint with the U.S. Department of Education's Office for Civil Rights, turned into a class complaint, not just about a particular student or set of students, but they looked at the district as a whole. And on numerous occasions, be it an access issue about a service dog, or an issue about discriminatory discipline, or an issue about special education services. I've done all of those things on all of the different laws that the U.S. Department of Education's Office for Civil Rights enforces.
Okay, no follow-ups. Question 8, how will you help ensure that the school district remains justifiably acknowledged by ODE and others as properly serving children with disabilities?
There are 3 ways to demonstrate that you know your stuff in special ed. Number 1 is successfully measuring student outcomes. I mean, that's the one thing that ODE is critically focused on, is measuring outcomes both at the district level as well as post-secondary outcomes. So your performance indicators and your measurements on all those statewide assessments, things like that, demonstrate that to ODE. I wouldn't be helping along those lines, but I certainly, in the defense of different complaints, use that information. So that starts with the district. The second way is in successfully defending complaints from the Ohio Department of Education. One of the ways that parents can register concerns about a district is to file an individual complaint that their child is not making educational progress, not getting this type of services that they need. Maybe they're not in the right school, they want a private placement, things like that. They have various ways to file complaints. One of them is just an administrative complaint with the State Department of Education, where the State Department will come, take a look at your paperwork, interview your staff, and look at student outcomes. The second way is through the litigation process, where they'll actually file a claim and, hearing officers assigned. And the way that I help school districts successfully position themselves are being at IEP team meetings, conducting professional development programs so that people understand that the cheapest way out of a problem is to not have it, is to prevent the problem. And so I do a lot of district in-servicing. I do a lot of, one of the services that we provide is an IEP audit service, where we look at your IEP documents and we design individually customized training programs for your administrators. We've developed a three video series for your building administrators, because we recognize that the professional development programs that we've put on often takes people out of district. And sometimes that's not doable for many building administrators. So we developed a video series that you can train your staff on your time using interactive, we call them mock IEPs. And so that we have those kind of opportunities so that when you are in a complaint situation, you're in a good defensible position. And the final thing that I do when you're in a complaint situation is I actually assist districts in responding to complaints. I put together all the information for the district. And because I have a relationship with the Department of Education, I have a lot of experience understanding what they're going to be looking for and how they want the information presented in the best possible light for districts.
Next question. Within the past year, our district has had high-profile incidents involving employee sexual contact with students. These incidents are destructive to our students, our district, our community at large, and damaging to the morale of our other employees. What proactive steps can we take to improve policy and abuse education among our employees and volunteers to assure that these incidents are minimized?
Well, since David's proclaimed that he was the king of misconduct, I'll let him chime in. But one of the things that I would weigh in on that is some of the things that I'm seeing from a student services perspective is it's helpful when districts provide some clear control about social media and how teachers and students interact. And I think that is tripping people up, and it's also leading to some incidents of inappropriate conduct. On the flip side, it does provide us with a ripe area to be able to search and be able to detect incidents of misconduct, particularly when you're looking through district provided cell phone devices or email accounts or things like that. So it's a double-edged sword, but I'll let David take this next one.
I mean, generally one of the things I do for districts is conduct sexual harassment seminars. So I'll come in and actually train anywhere from central office administrators to building level administrators to sometimes the employees themselves on what are proper boundaries, what are the definite don'ts when it comes to relationships with students, access to students, when it's appropriate to be alone with a student, when it's not, social media, things along those sorts. Obviously, there are some tools that are in place to deal with these types of situations. If you have an allegation of misconduct involving a staff member and a student, there's an obligation on the school district to immediately report it to law enforcement or children's services. And I know for a fact, years ago, that's enforced. And when you have situations, oftentimes what I've seen is situations in which you have a younger teacher possibly involved with a junior or a senior or an older student, where the building principal knew the families knew each other growing up, and it's, the rumors and the circulation are dismissed. Well, I always counsel school districts, you cannot put your hope in the fact that these are simply just rumors. You need to investigate those things immediately. It needs to be reported to Children's Services and possibly up to ODE's Office for Professional Misconduct. So.
Did you? No follow-up to that question. Since you got about 10 minutes left, I'll jump right into the next one. This has to do with Board of Revision matters. Does your firm currently have clients you are representing in matters against the Northwest Local School District? Have you had any in the past 3 years?
No, we have not. We have an individual in our firm. I don't handle Board of Revision work. I used to years ago. It's not a matter that you can dabble in. We have a dedicated tax attorney in our firm that handles Board of Revision cases for our school district clients. That's something that we'll hand off to John Brawlier, is the individual in our firm. He knows the law back and forth. We don't take adverse interest against school districts, so that wouldn't be something that I would handle, but we certainly have the capacity to do that.
Is he local or is he up in Columbus?
He's in Columbus, but he handles. Yeah, that's true. Mark Engel is actually local too. We have 2 tax attorneys in our Westchester office that are capable of handling that.
And as far as you know, neither one of them they've taken the position of a property owner against the district?
Correct.
Okay. Is there any follow-up questions? Okay. Next question. Do you have a full-time tax attorney or attorneys dedicated to the practice of municipal finance and specifically knowledgeable of sections 141 through 150 of the Internal Revenue Code, the accompanying Treasury regulations, relevant IRS revenue rulings, and private letter rulings relating to municipal finance?
We do. We have a very strong tax department. Like I mentioned, we have 2 attorneys in our Westchester office that are partner-level tax attorneys. We have a dedicated public finance department that provides assistance on school levies, bond issues, any type of municipal financing work that you would need done. We draw upon them on a regular basis. They're very good. So on both angles, as far as taxes, as far as public finance goes, and a lot of times those kind of issues sometimes pour into employee benefits. We actually have dedicated employee benefits that have been invaluable to our practice group in dealing with the Affordable Care Act. So.
Any follow-up? Next question. As a district, we depend on local property tax income and other sources to fund our operations. As our attorney, you may be called upon to examine the valuation claims of property owners and represent us as we challenge those claims. Please describe your experience with the County Board of Revisions, the Board of Tax Appeals, and the Common Pleas Court. Further, explain any additional experience you may have with this topic.
As I mentioned, I no longer handle Board of Revision work. Attorneys from our education practice group are not the individuals we send in to do Board of Revision work. We feel that that's a practice area that, again, you can't dabble in. We have dedicated individuals in our tax department that do that type of work and do it on a regular basis for public school districts across the state of Ohio. So if you're asking as far as experience at the administrative level, absolutely, we have those folks. Folks that can litigate in either the trial court, appellate court, or before the Supreme Court on those issues, absolutely we do. And I think it would be an upgrade to what you have right now.
Any follow-up? Are they part of the 19 attorneys that you described, or is that?
No, they're in our tax department, but they support. One of the things about our firm is oftentimes when we have legal issues that aren't within our realm of expertise, we give it to the individuals who do that work on a daily basis. And we have
Okay.
people that exclusively handle those types of things.
Okay. Dave, how many of those attorneys, the 19 education attorneys, are housed in the Westchester office?
We have 2 in the Westchester office.
Okay.
But again, there are folks that handle work across the state. Laura has quite a few education clients in Butler County and in the surrounding regions. And what she'll do is you charge for travel time from the Westchester office. She does not charge for travel time getting to Columbus, from Columbus, or long distance charges.
All right, thanks.
13, assuring that all property owners pay their fair share of taxes to the school district is an important objective of the board. Tell us how our board should craft a policy that will properly guide our legal counsel as to how this objective should be reached. What input would you want from the board in developing this objective?
As far as a property valuation policy,
And how we would pursue that?
I'm going to need some help. What I would do, I guess the first question is there an existing policy in place in this district? Okay. If there's not, then obviously if it was the board's will to create one, we need to do so. I would likely give a call to our dedicated Board of Revisions attorney, bring him in, likely either have a conference call or meet with you directly to understand the issues both from a school law perspective and from a tax perspective. And make certain that if there are tax issues that I'm not thinking of, I'm going to draw upon those resources. If there are school law issues that our tax person is not thinking of, that's where I come in. So it would be a collaborative approach.
Any follow-up questions? Question 14, what options are available to the board about making records available that are not covered appropriately under the open meetings law or public meetings law?
Are there specific examples?
For instance, student records are obviously private and you couldn't make those available. In this day of technology, there's probably all sorts of things you could make available and easily accessible. So what options are available to the board about making those, what options are available to the board about making records available?
Okay. I'll start to answer. Kimball, you jump in if I'm missing anything. Obviously, there are restrictions on what the board can and cannot divulge. Dan, you mentioned one, obviously, in student records. There are FERPA and I believe it's revised code 3319.321. God, it's sad that I know that. Prohibit the board from releasing personally identifiable student information. FERPA covers the information. State statute covers the record. So you're going to have some restrictions as far as that goes, as far as student records. You've got HIPAA issues potentially as far as protecting medical records. You have other limitations in regards to personally identifiable information such as social security numbers, student bank account, or bank account information, and various other records that I guess before the district would do anything in regards to making those types of records public, I would want a pretty thorough review of what exactly is going to be released. As far as the medium goes, I'm not aware of necessarily any restrictions as far as how those records can be accessed. If the board deems them to be public records and they deem them to be something that's appropriate to be viewed by the general public, I can't think of anything under the law that would limit how a member of the public can access those records necessarily.
Yeah, I guess I'll take this opportunity to let you know I did come with freebies here, so we're going to just set these down. I apologize. They're going to...
And I will mention you're down to about 3 or 4 minutes.
Okay,
So.
all right. Well, the only thing to follow specifically what you're saying, how to make more accessible. The top handout has to do with public records rules about what's available, and it's just a guidance piece. And I just brought it here tonight with a couple of other things as an example of some kinds of things we prepare for our clients. To make things more accessible, to me, I think the best thing is for, I think a lot of it's education with your staff and understanding that if a record is you have it electronically and can be retrieved with a normal request, it is considered to be as if it's on paper, as if it exists. And so that, I think that's just internal policy and training, because records must be provided and must be provided promptly as they're working along. And I think your staff understands that, the media, everyone will.
Any follow-up? Next question. How many public school districts do you represent? How many school districts do you currently represent?
I think we represent, either through our construction, our public finance, or our dedicated education practice group, over half of the school districts in the state of Ohio. I believe that's a fair assessment, although I have not calculated them. But I believe that when we, at one point, looked at all of our mailing lists, that's probably where our figure came down. But if you'd like an exact number, we certainly can follow up with details if that's important.
So you
the number.
Do the math, what are you talking about?
Around 300-ish.
That you do work for at least once a year?
Mm-hmm.
Okay. And any follow-up questions? And I'll go ahead and ask the last question. We've asked the same question to everybody. Are there any hidden costs with your fees?
Hidden costs. I don't know what we would hide. I mean, the fees are...
Maybe explain your fee structure.
Yeah. I don't know what hidden costs would be. We're pretty, it's kind of an open book in our fee statements.
Okay. That was all the questions, and you finished right about on time.
And who said lawyers can't be succinct?
Any other information we can provide for that hasn't been provided?
Not at this time, but you're welcome to stay for the rest of the meeting. I'd like to thank everybody who came out and spent time. What a wonderful thing to be able to listen to all these different, very intelligent attorneys talk about all the different aspects of school law. I feel like I've learned quite a bit in the last couple nights, and we'll move on to the next item. Next item, district law firm selection.
Do we have a spot where anybody in the audience can speak?
Did
we eliminate that for some reason?
Superintendent Jackson did not put that on the agenda.
It's not on the agenda because it's a special meeting, so it just wasn't included. But we can amend the agenda if the board desires to do that.
I would like to amend the agenda to, if there, and I don't know, there might not be anybody, but we do it for every other meeting. And Chris, I know that was something that you always felt was very important. So if we have people that are sitting in the audience and have any questions or want to say anything, I think we shouldn't not let them not speak.
I would be fine with that, Pam, as long as we put a real strict limit on it.
Yeah.
Yeah.
How about if we went till
10 o'clock?
10 till...
And there might not be any.
There might not be any questions. How about if, looking at that clock, we'll go till 10 till with that. So are you motioning for that?
Yep.
I'll second it. Randy, please call for a vote.
Mr. Detzel?
Aye.
Mrs. Detzel?
Aye.
Mr. Heather?
Aye.
Mr. Harlow?
Aye.
Mr. Unger?
Aye. Is there anyone in the audience that has any questions about the specifics that were discussed this evening?
Good evening. Again, I don't normally dress like this if I'm going to present something to anybody. But just talking about this district change in the attorneys, I mean, the whole thing doesn't really seem to be in the best interest of the school board or school district in general. Just something that's come across while I've been sitting here thinking is that as an incoming senior next year, when I go to graduate, something that I've worked so hard to get to, or something that I've worked so hard to get to graduation, that I'm going to walk on stage and I'm going to be shaking hands with someone that's not doing or taking actions that's going to be for the best of my education. That doesn't really seem like something that I or anyone in our community would be supporting. So knowing that that's going to be what's voted on now, and knowing that the interview of the majority's favored attorneys that was interviewed last week was not broadcasted on Waycross because they coincidentally couldn't be here to broadcast. That was a shady antic, and I wish I could have been here if I would have known that it wasn't going to be broadcasted. And along with that, something that just struck me during this individual board meeting, when someone's presenting something, and especially you care about it, Mr. Harlow, I don't believe that almost being asleep, like not even paying attention.
Personal attacks on board members,
I'm
please.
here, I'm taking notes, I'm looking up there, I'm looking at him. I mean,
Well, let's stay away from the personal attacks. Do you have something else relevant
well, no,
to the
just
meeting?
the fact that the obvious majority of the board doesn't support this, or obvious majority of the board supports something that's not for the benefit of the students of the school, that's not going to help the school district move on, our community move forward. I don't understand why this was even needed to be brought about. And obviously, someone that's been with our school district for the past 40 years, nothing's wrong with it. So I don't know why we're changing, why this all had to be brought into a meeting and a whole discussion. But I really hope that our school district or our school board can be smart about this and make the decision that's going to best suit our future. Thanks.
Thank you. Was there anyone else from the audience that would like to speak? And we're going to cut this off at 10 till, so.
Okay, I'll make it quick. I would just say that I have a concern over the last two meetings when I've been here. I've heard several board members say they don't know what we're looking for in legal representation, and they don't really know what the legal people do. They're going to look for input from other people, which I think is wise, and I think you'd be negligent if you didn't take input from other people. But having sat on boards and being a taxpayer, I expect people who represent me to vote not only from other people's advice, but from their own intelligence, their own education, that they should educate themselves on the issues they're going to vote on, especially when it concerns my money. And I'm a little concerned about the attitude that I really don't know what I'm voting on, but I'm going to take other people's advice. That just concerns me as a taxpayer. Thank you.
Thank you. Was there anyone else that wanted to speak? Mrs. Galk?
I may surprise everybody. What I'm going to say is that I was very impressed with all the people coming tonight, and you've got a hard decision to make. And just any decision you make, just think of the kids first, and it's going to be their benefit. Vote that way. And it's not. But I'm very impressed with everybody who's up here tonight. I was very impressed with it, and I really enjoyed it. Thank you.
Thank you. Was there anyone else that wanted to speak? We have a couple minutes left. Seeing none, we'll go on to, do you have comments, Andrew? You says you're going to make a recommendation.
I would like to make a few comments. I know we have a ranking for the attorneys, but a few things I heard from the board this evening and possibly last week as well. One comment is, and I've had this either in individual meetings with board members or at the meetings, is about we have vendors here at Northwest Local School District that have been here for a long, long time. And there's this perception that once you get in at Northwest, no one else can get in, et cetera. And maybe we've had complaints from vendors to board members that they're concerned that they can't get an opportunity to earn business here. I think that we have to remember that we're not bidding out hand soap in the restrooms and paper towels and paper and things like that. We're hiring an attorney. And if that is part of what's led us to this point, is because board members have gotten complaints that other law firms are concerned that they don't have an opportunity for business. Regarding law firms, that shouldn't be a concern of this board. The only concern of the board should be that we're doing what's best for our students, parents, taxpayers in terms of getting legal counsel. So I think we need to be very careful simply switching law firms because Innocent Roberts and Fisher has been here too long. In fact, one that we interviewed had been at Princeton for 35 years, and my guess is that Bricker and Eckler has probably had clients for many, many years, and probably Taft as well as some of the others. So I don't think that should be a reason to disqualify. But when I look at the different firms, here are my thoughts. We had Last week we had SMBP, and I didn't feel like we got a good idea of what they're capable of. I didn't think they were fully prepared to answer some of the questions. Regarding Finney Law, I thought they were knowledgeable about Board of Revision matters and possibly some open records, but I did not believe they were knowledgeable about human resource matters. In fact, I think the attorney they brought that would be the person doing negotiations had never negotiated a public school contract with teachers or employees. Also have concerns about access with that law firm. With Taft, I think they're knowledgeable in some areas. Part of the issue was their education attorney wasn't able to be here this evening, and I have concerns about he's out of Columbus, Ohio, and his access. And then there's a lot of questions that they weren't able to answer just because he wasn't here. In my opinion, my recommendation would be to stay with Ennis, Roberts, and Fisher for a couple of reasons. Is they're knowledgeable in all areas, and that I have really no concerns with them. If the board is determined to go with someone else, they would be wise to select Bricker and Eckler. Bricker and Eckler, similar to Ennis, Roberts, and Fisher, they're known for education law, and they support public education. And they're, one of the reasons why we had no follow-up question is because obviously they are very knowledgeable on all matters of education law. We interviewed them, I think it was a year or two ago. My concern is their Westchester office large enough to handle the amount of business that this district has, and I think that was answered through some of the questions, and then certainly they can bring some additional attorneys down from Columbus. But to me, it was clear who's qualified to be an attorney for the school district and who's not. And to me, it was clear that the three tonight were all qualified, and the last two, Ennis, Roberts, and Fisher, and Bricker and Eckler, were clearly more qualified than the other firms. And if this board decides to select another firm, I think anyone that was at these meetings and witnessed these are going to have some real questions, as they should, of the decision-making process that the board's making and using to determine who the attorney is for this for the district. I would also suggest, which and I know this probably won't happen, but I think it would be wise to allow me to meet with my AO staff and get their opinions as well. Our board policy allows for the board president only to contact the attorney on matters about my evaluation of performance and the treasurer's evaluation and performance, and myself, Tracy, Randy, we're the ones that really call the attorneys. So I'd like to get their input as well. So, I would also suggest the board wait until our July 14th or 21st meeting to act on this while we get some more information. But if, the determination is to act tonight, I would stay with Ennis, Roberts, and Fisher, and if they're determined to switch, I think it's clear that Bricker and Eckler is qualified. To me, they're both very well qualified. Those are my comments.
Okay, I guess we have a score sheet. If I can find mine in my...
Dan, can I make a comment?
Sure. And I'm fine with discussing how we should proceed. Maybe each board member should make a comment.
That's fine. That's
okay.
fine.
If you want to go second, that's fine.
I would like to start off by saying, first of all, and I think that was probably directed to me as far as the comment of not knowing what our attorneys do. And if that's what I said, we can go back and look. If that's exactly what I said, that is not what I meant. What I said was, or what I meant was, none of the five of us know everything that a school attorney does for our district. It is our responsibility to rely on the people that we hire to be the expertise of this district, being the superintendent, and then his team of HR, special ed, our business director, to have them put input on a decision that is such as important as this. And when we hear the superintendent ask us tonight, he would like to talk to his team. If we go ahead and just vote tonight without even asking him to do that, I don't think we're doing our jobs as board members and representing this community and our taxpayers. we are not here to micromanage. We are here to make the best decision possible. And I don't think that giving Dr. Jackson a week or 2 weeks to our next meeting to talk with his team for input is asking too much. So I would hope to think that this board, the majority of this board will do that and let Andrew talk to his team for the input. And again, I understand, I've been on this board long enough, I've sat through more expulsion appeals and hearings than anyone else on this board. I do know things that what our attorneys do. I just don't know everything that they do. And I don't want to make that decision just myself of who should be representing this district. Just like we hear our attorneys say, or I hope we hear them say, it's a collaborative effort. I think a decision that's as important as this should be a collaborative effort. And it won't be if we don't ask or take into consideration who our superintendent and his team feel the most comfortable, think the team that's the most comfortable. The other thing I'd just like to say too, with Taft, I understand that something came up and their educational person couldn't be here. And that concerns me a little bit because A, he's in Columbus anyhow. And so if he couldn't be here for this and they had nobody else in the firm to answer those questions, what's going to happen on a day-to-day basis when HR, whoever picks up the phone, and they're unavailable? That really concerns me. So I felt bad for the other two. I thought they did a great job picking up the ball, but that just doesn't look real good when you don't have anybody else in the firm to step up for a presentation for a job interview, and the main person be an education person. They had nobody else representing them. And I too, to me, Ines Robertson Fisher, I don't think you just get rid of them just because they've been here forever. With that said, I certainly think the last firm that presented is very capable to represent this district as well. But as far as the two last week, with the one Finney Law, it was 3 different firms. I mean, if we're going to do that, why don't we just pick one from each thing and we can hire 3 individual firms? They just pulled 3 individuals together, and the person that was the educational piece, I think he's retired. So I'm not even sure how much he's going to be willing to put time in. So I do have concerns with that as well. That's all.
Jim, did you have any comments?
It was obvious that we should stay with who we use right now, Ines Robertson Fisher. It was obvious. The 2 from last week, they have no school law experience. Like Pam said, Chris comes in, he's got 2 other guys from 2 other firms. We're hiring him to go out and hire 2 other firms to represent us. We have had no problems with our attorneys. They've been with us 37 years. They were clearly the best attorneys for school law. And you can argue with me all you want. They were heads above the best of the 5 that we've interviewed. And now I'm not taking anything away from anybody else. That's my opinion. I do agree. Andrew should talk to his team. They are the ones that work on a daily basis with our attorneys. And I think that's what we should do.
Mr. Harlow, did you have any comments?
I would like to say that I thought most of the firms did pretty well. I thought that the Taft firm, that I understand that duty calls, in this case almost literally, but that was a concern that the other 2 didn't seem as prepared as they could have been. Was a little concerned about the first one that presented the other night, and also I thought that the last 2 that performed tonight also did very well. I also think I was really impressed with Mr. Concanon of the Finney Law Firm, Finney Law Total, I should say, and that's what I never really think
Well, first of all, I thought that, David, your firm presented very well, as did Dennis Robertson Fisher, and Finney Law, I think, proved that they're not the two-headed monster that everybody thought they would be. We've been discussing this for months, and if you think that the team is going to come back with a different opinion than what their boss has said tonight, then you and I live in different universes. The team is going to come back and make the same recommendation. There's nothing to be gained by delaying this. And that's just my feeling. This has gone on too long. I want to put an end to this. I've told you many times, my brother's an attorney. I trust him more than anybody because he knows lawyers, he knows good ones, he knows bad ones. And when he gives John Concannon an A+, that resonates with me. He is the most pro-Northwest local school district person you will ever find, votes for every levy. Wife was a PTA president, Colerain High School. My thing that I'm looking at is, and this is going to be different than the others up here, but I'm looking at our culture, and I know where Finney Law stands, and they're on the same page as me. If you don't recognize that our culture is changing and going down, when we have 23 kids expelled in one day at Colerain High School, when I don't remember 3 kids in my 3 years there ever being expelled, if that, the culture has changed. And I am looking at this as also a cultural thing. I know that Finney Law and his people look at the world the way I do. And the majority, I believe, of the conservative residents of this school district. So with that said, Dan, I say that we have the vote tonight, and we put an end to this and put this to bed.
Thank you. My comments would be one on each of the firms. I thought the Schroeder firm, and not to leave out the other 3 names, they couldn't answer the first couple questions. They seem like they were customer service oriented, though, and they would go out and get those answers if they had to. I think all the firms would certainly, work hard to retain our business. The Finney Law firm, I've known Chris, and that's no secret, and I think I agree with you, Andrew. He would do very well with the Board of Revisions work. And as far as Mr. Concannon, I've never met him before the other night, or the other gentleman that was here, Gary Greenberg. Mr. Concannon teaches school law at Xavier University. I believe you were one of his students. I thought he was extremely knowledgeable, and Mr. Greenberg did take the time to read our labor and employment contracts, and he seemed pretty knowledgeable on that. The Taft firm, they're obviously the biggest of the bunch, and they would have a wide breadth of experience, and I regret that their education person was not able to be here this evening. Bricker and Eckler, I think you're brilliant. You really, not you, the one in the middle. I don't mean it that way. You really seem to know your business, and I'm impressed by that. Ennis, Robertson, and Fisher, we've all known Bill a very long time, and there's no question they know the ins and outs of this district. I sometimes feel like their thing they want to do is settle everything, and not to get into specifics, but we talk about who's negotiated labor contracts and who hasn't. I kind of disagreed with negotiating that contract 8 months before it was due this month, and I'm not sure how much push and pull went into it when it turned out the way it did, and I'm very happy for our employees.
Did you vote on it, Dan?
It was a 4-to-1 vote.
Okay,
And the reason
I'm sorry,
it was
I couldn't remember.
Let me go ahead and finish.
Okay, I'm sorry, I couldn't remember.
Only because, the new board was going to be encumbered with whatever the expenses were with that contract, and I had asked to table it that night, and it didn't get tabled, and that's fine. We had an elected board in 2013, and things went the way they did. I think when the association comes to us, realizing there's going to be a change on the board, and ask for, hey, let's get this new contract, signed now rather than wait till 2014, I think we might have been a little more persuasive in representing the interest of the financial interest of the board. I think all five, that said, I think all five of them are qualified, and there are some really brilliant folks out there. And as a person who's not an attorney but has spent a lifetime in private business, I find it amazing the level of education of all the different attorneys here who presented. So that said,
Can I?
if we're going to go on to second rounds, sure.
One thing I forgot, and I apologize. The main thing I'm concerned with Finney Law, I'll give it to you that Chris Finney seems very strong with Board of Revisions. And right now I know we have different law firms doing different pieces in our district. And it wouldn't be my first choice, but if this board felt that hiring Chris Finney to do our Board of Revisions, I would be comfortable with that because I know he knows his stuff. What I was really concerned with, and actually I've talked to a couple of you privately, and I know you felt the same way, was it Gary, who would be basically doing our negotiations? He came off so confrontational for an interview. I can't imagine what he would do in front of our teachers and our bus drivers. And I know one thing I was impressed with David is saying how when you negotiate, we're very fortunate here that we do have a good working relationship with both of our unions. I think that man would antagonize our unions so quickly that it would not be in the best interest of any of us. I mean, if that's how he comes across when he's trying to get a job, I can't imagine what he would do during negotiations. And like I said, I know several of you said the same thing. So how you could be comfortable going and knowing he would be a part of that team, I'm just not comfortable with that. I mean, how would anybody feel as far as, I know you want Chris Finney in here, bring him in, let him do what he's good at, let him do the Board of Revisions, and then let's pick one of the two firms from tonight to do the rest of it, because that's what they specialize in. These guys here, they know their stuff. They know special ed, they know education. So does Ennis Robertson Fisher. We need one of those two teams representing us in negotiations, representing us in special ed. Let Chris Finney do Board of Revisions. I think that'd be the best interest of this district if we're going to try to work together to do what's best for everybody.
We're past
I think we're past that point.
Give me 1 minute.
I think we'd have to, I think we're past that. We had an extra 10 minutes that wasn't on the agenda.
Well, I think that's sad. I'm a taxpayer, I think that's sad.
Does somebody want to motion to amend the agenda?
Greg,
You
I
don't
think,
need to amend the agenda to let somebody talk.
Well, I
Greg,
just want
I
to
think-
follow my
I get you.
Robert's Rules of Order. If you
I'll
want
make
to
a motion to please let the taxpayer speak for a couple
Okay.
minutes.
second, yeah.
Okay,
All right.
and how much time will you need?
1 minute.
Okay, we'll let it
I'll talk
go
as
for,
I'm coming.
and
I think
Greg,
it's-
you got to understand that I'm just trying to follow
I
Robert's
appreciate
Rules
you
of Order,
accommodating.
okay?
First off, I think it's sad that the board is not going to take the superintendent's recommendation on giving him a couple days to confront with his personnel here. I think that's very sad and upsetting. Secondly, I think it's sad that the board sits here and wastes my 4 hours of my evening, if I could have been home with my family, in my pool, enjoying my evening, knowing that you already had the decisions made a month ago. I think it's sad that you waste these three folks' times this evening and all the other attorneys that came for the last 2 weeks. I think it's sad that that decision was already made before tonight. You guys, I just think that's all I've got to say. I think it is sad and ridiculous that we wasted all this time. How many man hours? I'm sitting here 4 hours, and I'm upset. And I see we've got law enforcement here probably to keep somebody like me contained, because I think it's sad. I think it's sad.
My response would be, when we went into the architect hearings, I had no idea who we would end up with until we actually took the vote.
Well, this is deja vu all over again.
Well,
And it's sad.
I actually,
It's sad.
well, thank you for your comments. We've all had a chance to speak. We do have a score sheet if you'd like to rank your choices from 1 through 5. Does everybody have their copy of it?
Were you not, Pam asked if there was, about the Board of Revisions? Is that anything you guys are considering, or not?
I think we should have one firm handle, I mean, the dividing it up.
We use three different
I know,
firms now.
Chris
but
Finney's firm is 3 firms, Chris. They aren't even his, it's 3 different firms, and the one guy who you like so well, who, he was fine, he's retired.
I talked to him, Pam, he retired because these folks retire at 55 years old from the state. He was Cincinnati. He retired early.
Okay,
He's
but
not
we
going to
would be
retire.
hiring a firm that went out and hired 2 other firms.
I think every one of these firms uses subcontractors for different
I
purposes.
don't think so. I know that the 2 tonight didn't, that they're in-house.
I think
I
that,
I don't believe the other firms, at least the firms that presented tonight, do not hire subcontractors. I don't think you call them.
Ennis Robertson Fisher would have to go out for bond counsel, it looks like, based on their
And
question.
so will Finney. They don't do bond
Yeah.
counsel either.
Right.
Definitely use someone else for bond counsel.
We do have an in-house bond counsel.
We did, I did, yes, yes.
So actually, this firm sitting in front of us is the only firm that won't go out to get somebody, if you want to look at it that way.
I would ask that the board goes ahead and ranks these, and
Not that it makes a difference, you 3 have already got this decided, and I agree. We just wasted everybody's time, and the fact that you felt like on your own that you had to have a police officer here is kind of insulting to everybody sitting here. What did you think it was going to be, a riot?
the superintendent called him, Pam.
Did
I
you not ask him?
We talked about it, and
And did you
that's our-
kind of dictate it?
That's our school resource officer that we pay anyway.
And
So,
what- and isn't she normally off at 9? Or do
I
you
don't know her schedule, I don't micromanage like that.
Yeah, she's never at any other meetings.
Did you have a score sheet, Jim?
I do. I would like a copy of all 5 of them, too.
Okay, we'll do that. Can you put your initials on that, Pam?
Oh my gosh, I already said who I did there. It doesn't really matter, it's irrelevant. 17 years, this makes me sick to my stomach, the way we did this. You 3 should have just come in and ramrodded it through like you wanted to do in January. This is insulting to everybody, the whole process.
Pam,
It's embarrassing.
I was on the board 6 years with you, and I do not ever once remember when I didn't get my way, which was most of the time, when it was 3-2 with Bruce and I, or 4-1, that I ever whined and carried on and upset the crowd.
Nobody acted like this. This is...
Yes, they did, Pam.
Oh, my
When I brought up the uniform.
Chris, they did not, and you know
This
it.
is
Jim.
so
Watch it and listen to it.
unprofessional.
Jim.
We never
Okay,
had
Michael,
meetings
did you
where we
have
wasted
a,
everybody's
Michael,
time.
did you have a score sheet then, Chris?
Let's see.
Couldn't do the math.
And just for the purposes of, so everybody knows what it is, I will read off each one. The one from Mr. Harlow ranks Finney first, Bricker and Eckler second, Ennis Roberts Fisher third, Taft fourth, and Schroeder fifth. Mr. Heaters ranks Finney first, Schroeder second, Taft third, Ennis Roberts Fisher fourth, Bricker and Eckler fifth. Pam Detzel ranks Ennis Roberts Fisher first, Bricker and Eckler second, Taft third, Schroeder fourth, and Finney fifth. Jim Detzel ranks Ennis Roberts Fisher first, Bricker and Eckler second, Taft third, Schroeder fourth, and Finney fifth. I have ranked Finney first, Taft second, Bricker and Eckler third, Ennis Roberts and Fisher fourth, and Schroeder fifth. There are, Pam Detzel and Jim Detzel have each ranked Ennis Roberts Fisher as first. I've ranked Finney first. Mr. Heater has ranked Finney first. And Mr. Harlow has ranked Finney first. So we have 3 first places for Finney and 2 first places for Ennis, Roberts, and Fisher.
And no consideration for what the superintendent wants.
Every question that's been asked over the last 5 interviews, everyone has had an opportunity to ask additional questions and dig into what anything they wanted to know about these things.
That is what I asked. I said, I just wanted to go on record that you don't care what the person
Oh,
that...
of course I care what he says.
Really?
Yes, I
Really?
do.
How can you say that? How can you say that and put the firm that he's probably least comfortable with? And you care about what the person that we've hired to run the 2nd largest school district in Hamilton County, and you don't care what he thinks. Because if you did, you would not select the firm that he is most uncomfortable with.
I mean, Dan, you made him sit there back in January, interview one of Chris Finney's attorneys, and he came out and said absolutely he would not hire those guys to represent the district.
Well, Jim, it's obvious we have a difference of opinion here.
It's obvious. You 3 guys had your mind made up in January. You've stuck to it.
And then
And
you don't
that's what
even,
it is.
and then you just go the 1-1-1 and the 2-2 because you're scared to death that if you really do it and average it out, that actually if somebody else might get it over them.
You're not
Well,
making
I
the best
noticed-
decision for this district, the taxpayers. This is a personal agenda that you guys have. It's as simple as that.
And
Just admit it and just say, you know what?
Jim?
He's our friend, they're our friends. That's who we want as attorneys.
I personally think
They
that
do
Mr.
not have any, it is obvious. The 2 firms tonight are the specialists in school law. It's obvious.
You know, I would say that you
And
think
you
I
know
have,
it.
well,
You
let me
can't sit there and not
respond.
say
I'd say that if you think I have an agenda, I noticed that you and Pam both ranked Finney last, and at least they were able to answer every question.
I think that
Schroeder, let
man
me
is so
finish.
condescending and he's going to cause so many problems with us negotiating.
I know, but that's not what I'm
I will stand
saying.
by putting them last.
Okay, well, if that's your reason, that's fine. I
It
didn't
is
know
my
if you were
reason.
just...
I've said it all along.
And even though Schroeder couldn't answer several of the questions, you've ranked them ahead of them. I felt like Mr. Concanon was brilliant. And I think we've all agreed that...
He's one piece of the puzzle. The guy, the
Well, it's
other
not
guy
a
was
puzzle,
horrible.
but I think that Mr. Finney is very intelligent also.
Well, they're all intelligent. They're attorneys. They've made it through law school. They're attorneys. They're all intelligent. That doesn't mean that they're the right fit for this job.
Dan, can I add
Sure.
something? Folks, this isn't the federal judiciary where these are lifetime appointments. In a year, Elaine, please don't be moving around and disrupting the meeting.
What is she doing?
She's intermingling with the folks in the crowd.
Let's go on.
All right. Yeah.
She won't bite.
Okay,
Yep.
we are having a meeting.
The point is, let's try this. Let's see how it goes. This is not a lifetime appointment for 37 years. If it doesn't work out, we have to give 30 days notice to switch attorneys. I mean, this is not engraved in stone.
I noticed that they only have a $1 million liability where most of the firms have $5 million. I hope that we ask them to up it because I'm sure with their lack of knowledge, we could be looking at some liability issues. So I certainly hope when you guys negotiate the contract, you make them increase their liability insurance. Because it's funny how some of the other ones have $2 million and $5 million, and Finney only has $1 million.
Was there a part of the request for proposals that had a insurance
There was.
recommendation on it?
Certificates in there.
I mean, but was there limits as to what
It did.
What they should have?
We'll make sure that whoever is selected will correct that so it handles that.
So did they meet that?
I don't know.
Okay. Any other comments,
I'd have to
Mr.
get the
Harlow,
RFP
Mr.
out.
Heater, Jim, or Pam?
Is there a resolution?
Comments about what?
Chris, just make the resolution so we can just, I mean, let's just do it. I mean, that's what.
Folks, nobody's making you stay. Go.
Well, they might get in trouble for getting up or walking.
Yeah.
I mean, Elaine's not allowed
Okay.
to talk to somebody in the back row. I mean, crying out loud. So much for you standing with me at the polls, and the last thing you said to me, Chris, Pam, and you shook my hand. I just want to tell you right now, if I do get elected, I promise you, I'm coming in with no agenda. You are crazy.
Pam, you are obnoxious.
Okay, stop it. Stop it. Is there any motion?
I make a motion that we, the Northwest Local School District Board of Education, make as the district's attorney of record the Finney Law Firm, starting whenever practicable.
Second.
The motion's been moved and seconded. Is there any discussion?
All I can say is, everybody out there in TV land, if this doesn't get you to wake up and understand the importance of voting at the polls, and as Chris keeps telling us how elections have consequences, here it is. This is exactly what. We have a board that doesn't care what the superintendent recommends for this district. And I just hope that Andrew stays here with us because he is great for this district. But I don't know. I don't know.
We're already going to lose our treasurer. He's going to be gone. We've got to look for another treasurer because of this situation right here. This is the perfect example how we're going to lose good employees to other districts because of the agenda that these three have.
We already have. We already have.
We've lost our treasurer. Now we're going to have to find another treasurer. Who's going to want to come to this district when you have this kind of agenda going on? This is ridiculous.
Jim, we had 43 people apply for the principal's job at Coleraine High School.
Great. That's great.
People want to work here.
Principals don't work directly with the school board, Chris. You know it. The people sitting to your right directly work with the school board. Come on. Ask the treasurer why he's leaving. He's sitting right over there. Ask him.
The treasurer applied for a job outside of the district before Michael and I were even here 2 years ago.
So let's not get off track.
Ask him.
Staying
You
with.
don't want to ask him and get the truth.
Well, we can do that in an exit interview.
Call for a vote.
Well, it's still time for discussion. I would like to make one point that the Taft Law Firm actually used Mr. Concanon as a reference.
So what?
Well,
That's
just,
great.
I mean,
That's
they
fantastic.
certainly recognize his qualifications.
Okay.
And Taft is not a small law firm. They are.
No, they
I
couldn't
would
get the
say.
right guy here to present tonight.
Well,
They're such a
I don't-
large law firm with 200 lawyers, they can't even get their educational guy here tonight or someone to fill in for him. Don't give me that.
Well, in their proposal, which we all had a chance to read.
I don't care about their proposal. I want to hear what the guys had to say tonight. And they
I just
couldn't get
can't
their
believe
educational
that-
guy here or somebody to fill in for him.
Each
Well-
one of you did say that guy was confrontational, and yet
I did
you're
not. You and I haven't spoken since then.
Okay, I take it back. I know Michael because I said something and Michael agreed that he came across so confrontational. And yet you're okay.
Strong, I would say, but.
And that's what you are. We're
Andrew's
not
exact
the-
word. That was Andrew's
Well,
exact word, and I agree with
The only,
that.
the only other comment I would have is with respect to your motion, Mr. Heather, is I think we need to set a date for that. Is that 30 or 60 days, or
I'll amend my motion to say 30 days.
would that be?
30 days from, let's just say, August 1. That
So how
effective
do you,
August
how do you
1.
amend that motion?
I can restate it. Okay, move that the Northwest School Board make as the lawyers of record, attorneys of record for the district effective August 1, 2014, the Finney Law Firm.
Second.
And the motion has been clarified and seconded. Is there any other discussion about the clarification of the motion?
What else could we say?
I'm just trying to follow Robert's Rules of Order, Jim. I'll go ahead and call for a vote. Mr. Bertram?
Yeah, my computer just went down, Randy, so could you call it, please?
You still have to put the vote in, or we can't end the meeting. We're either in or out.
That, so you know that particular computer's having charging problems, you need to...
Just call it out so everybody can speak.
Is it plugged in down underneath there?
Yeah, it's,
Plug in.
Mr. Detzel?
Absolutely not.
Mrs. Detzel?
No.
Mr. Heather?
aye.
Mr. Harlow?
Aye.
Mr. Hunger?
Aye.
Make a motion to end the meeting.
As soon as I can get this to
Second.
advance.
Yeah.
Let me get this to
I
advance.
can't get to the next meeting, but I'll call the roll if you want to. Mr. Detzel?
Aye.
Mrs. Detzel?
Aye.
Mr. Heather?
Aye.
Mr. Harlow?
Aye.
Mr. Hunger?
There it is, adjournment.
Sorry you wasted your
Aye.
time.